Hello, I'm online now. I think it should work. Could you give me a feedback?
Test on the test.
Okay, I hear you.
Yes.
It should work now.
Hop. On peut pas monter un peu le son, ça? Do you hear me?
Yes, not very loudly, but I can hear you, yes.
Okay. We hear you.
Okay.
Okay. Good afternoon, everyone. If I can ask you to come in and take your seats as soon as possible, that would be wonderful. Please move into the room, find a seat. There are still a couple of seats, or maybe not. Yeah, there's a couple here, but we've got some rows here as well. Okay, yeah, feel free to take some of these front seats. That's great too. Yeah. And there are a couple over there as well. Feel free to take one on the front row. Yeah, go for it, go for it. Okay, marvelous, wonderful. Please. Yeah, it's great to see so many people in the room. What a full room, everybody having to chase for seats. So, welcome everybody here to the Standards and the European Patent System. This is the Patent Standards and Innovation Securing Europe's Competitive Edge. My name is Jack Parrock. I'm a moderator and journalist working with Euractiv, which is the media partner for this event. Delighted to have been asked to come along and play moderator for the first two panels, the early sessions, and then my colleague Dave Keating will come in and do the second two. Okay, I'm just going to take you through some parts of housekeeping to make sure that we're all on the same page. We're going to have those two panels, then a coffee break, just so you know there will be a short break. We've got a packed room, as we've seen, but we also have many, many, many people joining us online, and that's wonderful. Shows the huge interest in this subject. All of us, including in the room and online, are going to be able to use a tool called Slido, which will allow us to have some questions and put questions to the panelists, but also just to sort of make your statement while you're here today as well. If we don't get around to that question, the EPO team will also be able to view them and take into account what's happened, so it adds to the conversation. Now, everybody get their phones out. This is the way to do this.
Recording in progress.
Slido.com, and if you're sat watching us online, you can use it in the browser. So Slido.com, and then the hashtag that it asks you to put in is patents standards, pluralized, all one word. So patents standards, and you'll be able to put your questions to the panelists as we go throughout the whole of this event. So that's an important part of it. The questions, just for you to know, if you're directing your questions towards panelists, that's wonderful. The people that give our opening presentations at the beginning of each panel probably won't be able to answer those questions, but you can still raise points that they raise. Okay, that's enough from me. To start our event and to welcome everyone here, I'm going to welcome Antonio Campinos, the President of the European Patent Office, up to the stage. Please, wonderful to see you. Can we also have a round of applauses today? Yeah, thank you.
Good afternoon, everyone. I'm delighted to welcome you all to this timely event on patents, standards, and innovation, hosted in partnership with the French National Institute for Industrial Property and with the support of Euractiv. In today's rapidly shifting geopolitical landscape, the global race for technological leadership and strategic autonomy is intensifying. Europe must respond, and I do believe must respond with ambition, to work effectively all innovation strategies, including, of course, Mario Draghi's competitiveness strategy for Europe, require the involvement of all stakeholders in the innovation ecosystem. This is why it's so important that we have today with us industry leaders, judges, legal experts, academics, and policymakers in this room and online. Innovation also needs investment, and patents are an asset that attracts investment and enables businesses to grow. A patent is a badge of credibility, especially in high-growth sectors such as deep tech, biotech, or artificial intelligence. Alongside patents, standards. Standards are essential for market access. They drive interoperability and they build trust. They are at the core of a successful digital economy. There is good news. The European innovation ecosystem is working. The widespread global availability of mobile phones, 5G, video streaming, cloud computing, smart devices, and other technologies demonstrate that the system is accessible to the wider public and not merely reserved for a privileged few. However, even greater transparency would be beneficial, particularly for small and medium-sized companies. And that is why the EPO has, for example, made the Deep Tech Finder and key database resources such as ESPASnet, the EPO Patent Index, and its comprehensive library of studies on the innovation ecosystem freely accessible to all. Today I'm pleased to announce that the EPO is presenting a further new study to contribute to fostering a better understanding of the essential interface between the patents and standards. Building on decades of experience working closely with standard development organizations, the study shows that the relationship between European patents and standards plays a role in boosting innovation. But that is not all. We have also created freely accessible databases linking more than 5.5 million standard-related documents and 150 million patents, resulting in hundreds of thousands of connections with detailed information which, we hope, will help predict essentiality from patent standard traits. This is a particularly valuable feature that will bring more transparency to the market. But this is just one piece of the puzzle, and EPO will continue to develop and expand this patent standard linkage service in the coming years. This includes enhancing the data set, refining essentiality prediction methods, and of course integrating user feedback to make the platform even more useful for businesses, for researchers, and policymakers alike. At the same time, we must go further and find the right balance between patents, standards, legislation, and pragmatic solutions that work for all players, including SMEs and micro-entities, on an equal footing. We do believe that the results of this conference, the findings of the study, and the intelligence gathered in the dataset, hereby baptized, I think, Gilles, the Standard Patent Explorer, will feed into the 6-month consultation exercise announced recently by Commissioner Séjourné at the European Parliament. Concluding, I would like to thank the experts from the 21 national patent offices who worked with us to develop the study. And of course, I would like to especially thank Pascal Faure and his team for coordinating today's event. Merci, Pascal. We are also in Paris, home to the Central Division of the Unified Patent Court, and we are honored that the President of the Court of Appeal, Klaus Grabinski, and I think that another very important person of the court is here today with us physically, is joining us for the opening of the event. Later, also, the director of the Patent Mediation and Arbitration Center, Alex Zalach, will present for the first time in public, I think, his plan for the upcoming launch of the Patent Mediation Arbitration Center, especially regarding SEP/FRAND disputes. And let me close with this thought. Patents and standards are two key assets that contribute meaningfully to the success of Europe's innovation economy. But they do not stand alone. They are reinforced by cooperation, evidence, and trust. And today's discussions are about building all three. The EPO remains committed to full transparency and to supporting our collective fact-finding and evidence-gathering efforts. Merci à toutes, merci à tous.
Thank you very much. A big thank you for being here and for holding this event. Okay, yeah, as I mentioned, we're going to applaud everyone as they come up on the stage and as they go off as well. And the next speaker is Pascal Faure, the Director General of the French Patent and Trademark Office.
Yeah, bonjour. Bonjour à tous, ladies and gentlemen, dear colleagues. First of all, I would like to thank very much President Antonio Campinos and President Grabinski for their personal participation in this event organized at the initiative of the European Patent Office. Welcome all in Paris. I would like also to thank the speakers, participants, organizers who made it possible to hold this conference dedicated to strategic topics today, standard essential patents, SEPs. And today our remarkable audience brings together intellectual property offices, IP attorneys, industrial actors, judges, academics, as you mentioned, Antonio, and institutional representatives. This diversity confirms the importance of a collective reflection in which each expertise contributes to build a balanced and relevant approach. As highlighted in his recent report, Mario Draghi points that competitiveness must be at the heart of the European strategy to make Europe less dependent on major economies like China or the United States. This is within our reach because, you know, the European Union is the second largest world economic power and number 3 in terms of demographics. So, however, such a strategy cannot be effective without the systematic use of industrial property, in particular patents, which are essential to ensure our sovereignty in crucial sectors such as health, energy, digital technology, and automotive, for example. And this is even more necessary as innovation is shifting eastward in many fields. Today, Asia drives the global dynamic of patents filing, accounting for more 2/3 of all patent applications. Therefore, before being essential for, excuse me, but with the microphone it's difficult to see my paper, you see, so you can confirm that. So, and I did my paper, sorry. And I say that before being essential to a standard, a patent is essential to the competitiveness of the European industry and companies. So by providing a time-limited exclusive right, the patent ensures a fair return on investment for those who innovate and take risks. If building a patent portfolio is important, we are all aware of that, an innovation only becomes truly successful when it finds its market. And standards which define a common language and contribute to the interoperability contribute to accelerate the dissemination of technological innovations. For example, from the 5G networks to connected devices, standards have facilitated the massive adoption of digital technology within other sectors such as health or automotive and enable the emergence of global markets. Thus, SEPs combine two major advantages. On the one hand, they grant an exclusive right to the holder, and on the other hand, they allow the technology to be widely disseminated, as you mentioned. This particularly makes them a crucial factor in creating a sustainable, competitive, and open economic environment. However, the balance between protecting innovation and making technologies accessible is a delicate one. This balance has long been based on the principle of self-regulation. The European Commission estimates that around 600 SEP license agreements are signed each year, involving approximately 230 implementers based in the European Union. This volume shows that, despite of the complexity of negotiations, numerous FRAND contracts have been agreed over the past decade. However, certain practices, such as over-declaration of SEPs, indicate that self-regulation does not always guarantee a fair and efficient operation. A more readable regulation may then become necessary. The Draghi reports also mentioned the need to reduce the administrative burden on companies. More than 60% of the EU companies perceive existing regulations as an obstacle to investment, and 55% of SMEs report that the administrative hurdles pose a major challenge. Therefore, any new regulation must offer a fair balance between protecting innovation, promoting a widespread dissemination among users, and being efficient for the companies that rely on it. Establishing such a framework of trust is a common, useful, and complex goal. I believe that we share another responsibility. We have to help companies to understand the concept of SEP patents by raising their awareness. Companies need to understand in advance what the rules are, what constitutes an essential patent, what a FRAND commitment means, and how a negotiation should be proceed. It's also important to improve transparency. Access to information is essential to enable all stakeholders, and specifically SMEs, to make enlightened decisions. Besides the accessibility and clarity of SEP declaration with standardization body, the ability to verify their essentiality, and the understanding of the proposed FRAND license terms are all aspects that need to be improved. In this regard, we should take advantage of the fact that intellectual property offices or the patent registers containing information on validity, scope, and the existence of licenses to enhance this transparency. And finally, as it is stated also in the Draghi report, the unitary patent system and the UPC are also essential tools for developing a common and readable body of case law that strengthen the coherence of the European system. We must also promote alternative dispute resolution methods, and in particular the mediation. In the field as technical and global as SEPs, mediation offers numerous advantages: speed, confidentiality, flexibility, and above all, the possibility of reaching balanced and sustainable agreements. Once again, we welcome the appointment of the director of the UPC Mediation Center last September. So, ladies and gentlemen, to conclude my speech, I hope that this afternoon's discussions will shed light on these very complex but very important issues. So I wish you fruitful exchanges, and once again, thank you very much for your much appreciated presence today. Thank you.
Thank you very much indeed. I'll try and get these sorted out in a second. Let's now bring in, thank you so much, Pascal. We'll bring in Klaus Grabinski, as mentioned, who's joining us online. He's the president of the Court of Appeal and chairperson of the Presidium of the Unified Patent Court. I hope we can see him with us. I saw him earlier when we were setting up, so fingers crossed.
Yes, you may hear me.
Yeah, there we go. Klaus?
Okay, I'm online.
Nearly.
Okay.
We're just going to get you onto the full screen somehow. Can you talk for us, please, Klaus? We can see if we
Yes, I can. Do you hear me?
Now we've got you. There we go. I will leave the tech team and I'll have a look at these microphones in the meantime.
Yes,
Yeah, he's there. Please,
okay,
Klaus,
perfect.
continue. We'll get you onto the full screen as you continue talking. Thank you.
Okay, perfect. Jack, thank you very much. And first of all, I would like to thank the European Patent Office and its president, Antonio Campinos, as well as the Institut National de la Propriété Industrielle and its Director General, Pascal Faure, for making this very important event on patents, standards, and innovation possible. Dear ladies and gentlemen, it was good news when the Commission in its work program 2025 announced that no agreement on its proposal for a regulation on standard essential patents is foreseeable, and that it will be assessed whether another proposal should be tabled or another type of approach should be chosen. Putting this project to a halt was good news because there were serious doubts whether a mandatory FRAND setting procedure before the EU IPO of a duration of more than 9 months during which no court action could have been pursued as provided for by the proposed regulation would have been conflicting with the fundamental right to access to justice as guaranteed by Article 47 of the EU Charter of Fundamental Rights. It was also unclear how the EU IPO could have dealt with essentiality checks of national and European patents as provided for in the draft. For doing an essentiality check, the patent claim must be interpreted to find out whether a product that falls under a standard also makes use of the patent. Claim interpretation, however, is governed in case of a national patent by the law of the respective EU member state, and in case of a European patent by Article 69 European Patent Convention. How could the EU IPO as an EU agency have applied the national law of an EU member state or Article 69 European Patent Convention, which both are not EU law? Would the EU IPO have followed the case law on patent claim interpretation of the respective national courts or the UPC or the EPO boards of appeal? Another issue would have been who would have become an evaluator or a conciliator under the SEP regulation. When the UPC opened its doors, the credit it was given by the stakeholders resulted largely from the fact that most of its judges had already gained a reputation in the national courts. It would not have worked the same with the evaluators and the conciliators under the draft SEP regulation, and it was never explained where sufficiently qualified candidates for these positions would have come from. With all these open questions, it is a wise decision to allow the time for a rethinking. In the meantime, and just 2 years after it began operations, the UPC became a busy forum for dealing with patent litigation in general, but also with SEP litigation in particular. As of 30 April 2025, 305 actions for infringements on the merits alone have been filed with the UPC, out of which 23 cases have been SEP related. In some of these cases, the UPC Court of First Instance has already issued decisions on the merits, like the Mannheim Local Division in the Panasonic Oppo case and the Munich Local Division in the Huawei Netgear case. That shows that the UPC can deal with SEP-related litigation in a timely manner. In addition, the UPC Patent and Arbitration Center is on the horizon and will open its doors end of this year or early next year. It could be the right place for parties who wish to resolve their patent and, in particular, their SEP disputes by way of alternative dispute resolution. Against this background, it might be discussed on the various panels this afternoon whether there is still a need for another proposal for a regulation on essential patents and how the handling of SEP-related cases by the UPC and also the future UPC PMAC could be developed. I would like to leave it there and hand it back to you, Jack, wishing you all an inspiring debate. Thank you very much.
Patents and standards, and he is the stream leader for legal and innovation policy at the EPO. So a round of applause for him. He's going to take a stick mic as well, I think, right? Let's give it a go. Maybe turn it on. There we go.
Now, perfect. So thank you very much, Jack, for your introduction, and hello, everybody. If we are here today, is because we all agree that technology standards are important for the digital sector because they ensure seamless connectivity across devices and facilitate a rapid diffusion of technologies. The patent system, in turn, is important for the development of standards because it provides the incentives to invest in research and development, to exchange knowledge, and it also facilitates coordination across actors. Right? This strong relationship between the patent system and the standard system can be already observed in the latest release of the EPO's patent index, where we observe that these technology fields where standardization activity is important lead in terms of numbers of applications filed at the EPO. Now, predictability, transparency in the relationship between patents and standards is important for European competitiveness, and this is precisely why at the EPO, at the EPO's Observatory on Patents and Technology, we have an ongoing program on standards and patents where we study the interplay between both. Now, this program has a dedicated webpage that has been launched today. It can be found at epo.org/standards, and you are very welcome to check it out. The first deliverables of this program are a new study and a new data set. The new study has two parts. The first part studies the relationship between patents and standards, building on the EPO's unique collection of SDO documents used in prior art searches. Examiner citations to these documents provide a natural link between patents and standards that we have compiled into a new data set. Right? Both the study and the data set have been launched today, and you can find them in the website epo.org/standards. The study has a second part, which studies SEP litigation in Europe in the last years, which will be presented in session 2 by my colleague Justus Baron, lead author of this chapter, and together with his colleagues at Brella. So, going on to present the first part of the study, what we provide in the study is an overview of how standards documentation disclosed during the standards developing process is integrated into the EPO's patent grant process. Yeah? When a patent documentation is disclosed, this is state of the art under the European Patent Convention and must of course be taken into account when assessing essentiality. When assessing the patentability of an invention, right? That is inventive step and novelty. And to make sure that this is done correctly and to the highest quality standards, the EPO has been, since the early 2000s, investing significantly in collecting and incorporating SDO documents into its internal databases used in prior art search. Now, these databases, as of now, include more than 5.5 million documents disclosed to different SDOs. And these documents are not just compiled, they are, their bibliographical information is extracted, is incorporated into EPO search tool and SERA to make sure that examiners can search these documents efficiently, resulting in high quality patents in standards, in technologies where standardization is important. So these documents come from 13 different SDO databases established through agreements with 15 SDOs. Most of these documents, about half of them, come from 3GPP. This reflects the importance of standards such as 3G, 4G, 5G for the digital economy. And we have also many documents coming from other databases and other SDOs, such as ITUT, other ETSI databases, IEEE, and video-related standards. These databases are widely used by examiners. In 2024, about 5%, slightly less, of all search reports at the EPO cited at least one document in these SDO databases. But when we zoom in, into examiner units that deal with applications in areas where standardization is important. These percentages are much higher. For instance, in wireless and data networks, more than 30% of the search reports include at least one citation to SDO documents in the databases. Now, these citations to SDO documents by examiners provide a natural link between patents and standards that we have collected into this new data set that we have branded as the Patent Standards Explorer. Right? This is not the ultimate data set on standards and patents. It's a data set that comes from the ordinary activity of the European Patent Office, and we have collected it in an effort to help increase clarity in the relationship between patents and standards. And it's just one step in a sequence of milestones that we will keep contributing to. Right? So just one point in a broader agenda of our program. This data set, what does it include? Well, it has nearly 170,000 distinct documents in the EPO-SDO databases. Note that this is about 3% of the 5.5 million documents included in the SDO databases used for prior art searches. So it's a very, very selected sample of likely very relevant SDO documents. These documents are cited by more than 220,000 patents, more than 400,000 times. What we provide is structured bibliographical information for these documents, including identifiers of the documents and the patents citing these documents, authors, title, working groups, document types, dates when the document was published. And we can extract this structured information because we structure it when incorporating it into the EPO's search tools. Right? And this facilitates this structured information. Another thing that's important, the data set includes a link to the citing patents, which means that it can be linked to all the PatStat products and also facilitates for an analysis on how patents and standards are related. So all the wealth of PatStats products can be used. And it's publicly available, again, at epo.org/standards. So any one of you who might be interested in it can go to the webpage and download it. This is an extract, a snapshot of how the data set looks like. So please, if you're interested, do not hesitate to download it. Many of the documents in the data set are indeed contributions. This highlights the dynamic nature of standard development and also the importance of taking into account not just final specifications, but also intermediate contributions to working groups. And to conclude my presentation, the data set has many potential use cases, and what we would like really is for you and interested users to download it and explore what these use cases are. We have some ideas of what these use cases could be. For example, the data set could be used in academic research to study the dynamics of standardization and innovation. Yeah? It could be used by practitioners for use cases of interest to SEP holders, SEP implementers, to identify commercial relationships between authors of cited standards and owners of citing patents. And it could also serve as a valuable foundation for establishing methods to predict essentiality. You know, we're not saying that it uncovers essentiality, we're saying that it could help in establishing methods to predict essentiality. And relating to this last point, what we find is that citations to SDO documents strongly correlate with a patent's likelihood of being declared essential, with almost 40% of declared SEPs citing SDO documents. Yeah? This was my last slide. Please, we invite you to check out our webpage, download the data set, read the study. Thank you very much for your time, and I'm very much looking forward to the panel discussion with a great lineup of speakers. Thank you all.
Thank you so much. Thank you. Yeah, this one. you can take a seat as well, I think. Yeah, yeah. Thank you. So I just want to apologize to everybody online. Apparently the microphone that was attached to me wasn't working very well. Luckily, the things that have been said by everyone else are much more important than what I've been saying. But there is one point to note, that the Slido tool that we're using, slido.com, and then use patents standards as the hashtag, that will take you to the page where you can bring in your questions. But in the meantime, I'm going to invite my panelists up to the stage, those that are in the room with us. And I'm going, yeah, please come and join us. A big round of applause for them. And to everyone online. So we're going to get into this. Please turn your microphones on as well. So online we have Kirti Gupta, who's the Vice President and Chief Economist of Global Technology at Cornerstone Research. Is she there with us? We hope. We will see her as she comes up. We have Benno Buhler, who is the Vice President at Charles River Associates. Thank you so much for being here. We also have Bowman Hayden, who is the Director of the Center for Intellectual Property at the University of Gothenburg. He's also online, we hope. Yeah, they're there. They are there. I'm not sure we can see them yet, but they're present and correct with us. And we have Rudy Beckers, who's the Professor and Chair of Standardization and Intellectual Property at Eindhoven University of Technology. It's wonderful that you're all here. We're going to start, actually, with Kirti, if we can get her up. And the first thing we'd like to ask, something of a brief reaction to what you've seen just presented there from Pere, how that matches your overall outlook of the sort of current landscape.
Thank you. Good morning, everybody. Or afternoon, can you all hear me?
We've got you.
Okay, excellent. Well, I just thank you all for doing this, for launching this initiative. You know, very quickly, I've been working in the standards and patent space for a while. I currently serve as an expert on standards, IP and competition issues at Cornerstone Research in regulatory and litigation proceedings. And before that, I spent 21 years at Qualcomm, most recently as the company's chief economist, working on all things valuation, licensing, litigation on IP SEP matters. But I've also worked as an engineer, specifically going to standards bodies, to 3GPP standards, and I have patents. I have standard essential patents. So it's a great pleasure to see this report that you all have launched. Huge kudos, because, you know, coming from the deep trenches in this world, both as an engineer and as an economist, and looking at the data, thinking about, you know, actual practical use in real ways for the linkages between standards and patents, I can say that, you know, I have the sort of the perspective for a long time to have, you know, even commissioned and pulled, started research projects for pulling together data like this. I'm really pleased to see something like this from the official channels of the EPO that I think could be a game changer. It could make a big difference in creating this linkage. Just quick perspective, right? If you go to, for example, one of these standards bodies, let's say the important one, 5G and 3GPP meetings, there are currently 17 working groups with hundreds of engineers, with hundreds of thousands of technical specifications on which 50 or 60,000, you know, potentially essential declared standard essential patents may read in different parts of the specifications. It's a maze, and it's really difficult to understand what links to what, and which patents are potentially related to which technical specifications, and which ones are potentially essential. So it really leads us to an important linkage. So I'll pause there and
Thank you so much, Kirti. Yeah, I mean, that's a nice thing for you to hear, a gleaming assessment of what we've just heard. Benno, let's come to you. Let's talk about transparency. Let's talk about the efforts to improve transparency. How successful have they been? Perhaps you can give us a bit of a lay of the land there.
Yeah, thank you, and I feel really humbled to be here today and discuss this with you, so that's really great. let me also second Kirti in her kudos to the EPU's great effort here in publishing that study. I should say that, and this brings us back to your point of transparency. Transparency is essential, and it's so important for for the market to work, because I mean, I'm an economist, and in economics we learn that to have efficient transactions we need transparency. So it's effectively it's the oil that keeps the machine running, right? Now, let me quickly spend a few words on where I think we are and why it's so essential and so important for the EPO and also for other institutions and other bodies to foster transparency. And I should also link this back then to the SEP regulation that Klaus already mentioned earlier on, because that was also an attempt to improve transparency in the market. So let me basically provide you my perspective on where we are.
Please.
Now, I think we did already do quite some progress. So I think a few decades ago, probably we had really problems in navigating at all the whole SEP arena. But let me maybe give you a few thoughts on a few dimensions on what I think is essential in doing transactions and in the licensing activities. And let me start with facts and on the parameters of trade first, and let me then come also to transparency on prices. And to start with the parameters on trade. So there's, on the one hand, we have something that is, I would call just landscaping, sub-landscaping. We heard a bit that there's hundreds, thousands of standards, of course, and we need to understand what is the stack, how large is the stack, who are the key patent holders in the stack, right? And here we have, of course, some benefit from declaration databases that you also mentioned, Perre, and that helps us enormously. So on standards like cellular, this is, of course, very useful. But let me also emphasize here that there are lots of other standards, very important standards, key standards like Wi-Fi, like video, right? Where we don't have declaration databases, we have these blanket declarations. So essentially, we are in the dark. We don't know what the stack is. We don't know who are the major stakeholders. I'm maybe exaggerating a little bit because there are, of course, attempts to bring light into the dark. But let me tell you also that this is really imperfect, and this is really where we need some more progress. And that's also one of the points where the SEP regulation, as I understand, was really trying to be ambitious and getting a bit more light into the dark. So that is basically this landscaping. Then let me also mention on essentiality specifically. So we have these declaration databases. I mentioned them. They tell us basically what are the patents that are declared essential, but of course we don't know whether they are essential. We know that from studies that Rudy did. We know that the essentiality rate can be as low as 20%. So we know that only 1 in 5 patents is actually essential. So it's an important question, what are the essential patents, what are not. So on essentiality, this has been so far a quite manual endeavor actually. So it's one by one going through the patents or families and then basically checking whether a patent is likely essential or not. I should also say that this is something where that is largely done, by private firms, by patent specialists, patent lawyers, and so on and so forth. And the point is, with these things, if you organize privately information gathering, then of course one of the results is that this information gets who buys it, not everybody, right? It's not socialized. So one does the research, the groundwork, and then it's sold to a few people, but not to everybody in the market. So. And again, in the interest of time, let me just report back, if you want, from the trenches that, in most of transactions, we are either not having essentiality data because the clients can't afford it, or we are not using it because there is, if you want, there isn't really much anonymity on high quality providers on actually how essentiality testing should be done. And basically, if you look into the correlation between different providers, you will see that the correlation isn't very high, and really smiling here, right? And you also hear, and it doesn't take much to just read through a few judgments, and then you will see that judges also are not too credulous actually, or not too relying too much, if you want, on this essentiality information. So to cut it short, I have cases where we have hundreds of millions at stake, and where the parties are deciding not to use essentiality data because it's not reliable enough, because it's not worth it. They have it even at their fingertips and they're not using it. So if you want, so there's quite some way to go. Now the the silver lining, and I've stopped soon. The silver lining is, I would say, AI. Now, AI might be a game changer, and you mentioned already that, like you pointed out that you see your study as, some contribution to, have some indicators on some correlation, if you want, on essentiality. I do think actually that we will soon see something, or we do see already something, where we get much more, where we get basically large language models, where we then have, also some AI drafted report, if you want, and we can then also cross-check whether what's in there makes sense or not. So if you want, there is already technology coming, and now I get back and, take my economist perspective again. So like we're coming from a world where essentiality testing has been very expensive. And that's why we haven't relied on it an awful lot. Right now, the cost of this technology is decreasing because we can use AI. And now my question is, basically, if the cost of getting some information gets cheaper and the quality gets higher, then this means that actually we should rely on it more, right? And then in that sense, I find this interesting because there have been a few studies in the making a few years ago, and Rudi was very active here. And that was also one of the themes of the SEP regulation. And so in my view, like from an economic perspective, if costs are going down, if everything is set, to use that information, then I would say, let's use it. And I stop here.
No. I mean, and that's kind of the part of the balance and the crux of a lot of the discussions we'll have. There will be lots of perspectives throughout the rest of the afternoon on what you've said. Let's bring in Bowman Hayden. And perhaps you can talk a bit about the standardization and patents ecosystem, your assessment, what you've heard so far, what you heard from the study as well.
All right, thanks very much. Can you hear me all right?
We've got you.
Great. And sorry not to be there today. I always like to participate in EPO events. And of course, it's nice when they're held in Paris. I'm actually in a rainy New York City today, although I have a nice sunset in my background here. I'm going to try to paint a bit of a broad, rosy picture, I think, building on, I'm going to move out of the trenches. I know that there's problems in the trenches, but I'm going to try to show the big picture, building a bit on what Kirti said. And so it's important to know that open standards based on significant R&D investments depend on patents to be successful. So this is counterintuitive for some because patents are rights to exclude, but patents are also critical to facilitate open innovation, which is the case in open standards. So it's important to know that patents are critical for creating standards. One could say that patents are essential for the development of open standards. Excuse the pun. If we take cellular standards as an example, which Kirti mentioned, the mobile economy has been very successful. It's greater than $5 trillion every year in value. So in the trenches, it's challenging, but people are obviously able to accomplish quite a lot, right? In 2016, the number of cellular phone subscriptions surpassed the number of total people on the planet. The poorest people in the world have mobile phones. So why has this been so successful? Well, it's due to this multiple layers of collective private action by global actors. So private actors conduct billions of dollars of R&D and compete to have their technology adopted in open, consensus-based standard development organizations, which requires millions of person hours and hundreds of firms, as Kirti mentioned. Technology contributors agree to license their SEPs on FRAND terms, which both compensate the SEP holders and facilitate the dissemination of standards downstream by SEP implementers. Furthermore, collective rights organizations are formed, such as patent pools, to more efficiently manage licensing between many SEP holders and implementers. More solutions are being created all the time to make SEP licensing more efficient, including a new license negotiation group models and improved sources of information, which you've heard about today from the EPO. So all in all, open standards are quite amazing ecosystems, blending both collaboration and competition on a global scale, where patents play an essential role. So in the trenches, it's difficult. From the big picture, it's amazing.
Thank you so much for bringing positivity in bucket loads there. I'll come down to you, Rudi. As an academic who studied both SDO, prior art citations at EPO, and on essentiality assessments, what are your first views of the report that Perry's put out and what you've heard so far?
No, thanks of all. First of all, thanks for having me here. And I got very excited. I spent, quite a couple of hours and nights reading the report that it was just out now publicly and trying to really get through it. So I'll go a little bit more in detail on the data that we're seeing and applications in academia, business, and policymakers perhaps as well. Because this is super exciting. I mean, why I get excited, I've been using myself this SDO data, which was kind of buried in PodStat already for long ago, and now we got it as a full data set. We got a lot of valuable metadata with it, making it available to everybody. So this unlocks, I think, a great resource here. I also, of course, got excited because I'm very interested in essentiality, having done work on that with the pilot study and other things. I'm going to try to bring these things together. So having this new database, I think it's really a fantastic database. Having this metadata, having this detailed information basically about these linkages between SDO citations and the patents is wonderful. We got a couple of tasks coming up relating to the names of these documents, for example, the names on patents and other stuff. And there's one thing, of course, peculiar about this type of data, that unlike much of the other non-patent literature data where we can actually look at it and see the actual source, this is type of data where we can see all the metadata but not what underlies it. That would be more the SDOs that basically are the owner of that information, and that is an inherent limitation here. We got a nice coverage of standard setting organization. I already like what I'm seeing there. I also see in the report you talk quite a bit about quantum technology and AI, so I hope really that EPO will be bringing this forward to other organizations as well. If we talk quantum technology, I think we need to be at Sensane like GTC 22. That's where the quantum stuff is happening. So I think, and I hope also in the future, these are considerations that we get a broader database here. Now, people already started talking about linking this to the question of determining essentiality. And of course, that's the first thought I was having as well. And I must say here, I want to be a little bit cautious here and share that caution with you. And I have to go a little bit into technical details, but I know a lot of people here are patenting experts, so you will know what I'm talking here about. So why exactly is that caution for me coming from? Let me try to explain it. We talk here about SDO citations that are made in the face of the patent search. So this is on the basis of the patent application document. And now if we look at these citations, and if we also look in the EPO report, many of these citations are known as X or Y citations. They are blocking citations. It basically means that the patent, as proposed by the applicant, cannot be granted in that form. They basically block because of novelty, mostly in the case of X, or because of challenging inventive step, because of a combination of two Y documents. Now, why do I care about this? Because if actually this SDO document that we're referring to about, if this is actually about the essentiality we're talking about, this is an interesting observation, but these patents can never be granted as they are. It has to be taken out, basically, and then the essentiality is likely gone. Then we have all these other documents. The other half is A references, A citations, so they are not blocking as such, etc. But there actually you find already in your study they're not significantly significant. You got hundreds of thousands of them and don't find it significant. So I think the next challenge is really getting to understand this data set better and really what does it tell us about actual essentiality. It tells us something about declared essentiality, we can see that, but really about actual essentiality, it's a much more complex picture, and I look forward to finding this out with people. We have to see how it works, and it might be even a reverse relationship, a negative one if you really think about it very well. The proof of the pudding basically is here. We need something to compare it against. I think we need altogether a good data set of actually essential patents that we assess, and then we can test AI systems, how well they're doing. And we can test how this database is giving us good indications. We can test other things. But we are in the dark when we don't have a good high quality comparison point basically to test what type of indicators are giving us what here. And I'm going to leave that here because we certainly have more things to talk about. But these are my first reactions. And again, kudos for the work. I think it's a very interesting data set. I see quite a lot of use cases myself, and I already have ideas for studies myself, but a bit cautious about using it for true essentiality predictors. Thank you.
Jack, can I add something? I think it might be valuable. So it might be remiss not to share this perspective coming from the trenches, from the practitioner space. Look, I've been in the rooms as an engineer trying to assess essentiality, potential essentiality of, patents declared as potentially essential. And I do want to add a word of healthy caution, because data is something that we love, as, Rudy's talking about, we're from the research community. But once we try to use it for practical things, and like, Bruno, you were saying for, cases where stakes are high, it's important to recognize that the data can only take you so far. You have to ultimately get the practitioners technical assessment, because you're really chasing two moving targets when you're trying to determine, let's say, essentiality of a patent, right? The patents are evolving because the claims are being prosecuted in different patent offices around the world with all these things that Rudy was saying, right? Like looking at prior art and etc. You guys know this, you're sitting in the patent office. And second, the standard is evolving. And this is something that, most people maybe not fully appreciate, that it isn't like a one and done thing. It's an evolving system. Each generation of, let's say, a 4G or a 5G cellular standard takes around a decade. It takes a long time for these features to evolve and develop with a lot of interactive, conversations. So when you're trying to think about looking at a patent and really with the best knowledge that you have, trying to think about whether this is going to be adopted in some way in the standards, even for the most skilled and deep in the trenches professionals, it is a prediction. So I just wanted to recognize that in any of the efforts, that we use for this data set.
And so let me maybe also add to what Kirti just said, because about prediction and this eternal chase for the perfect data. Because in the end, what we are interested in is the question: does the patent read on certain parts of a technical, of a technical specification, if you want, of some part of the standard, as Kirti called it, right? Now, declaration data can map, is essentially a mapping on the standards, and it allows us to tell whether a patent has been declared on one part of the standard or on another part of the standard, right? I say we can do exactly the same also with essentiality. We can say, look, this patent has been found essential on that part of the standard and this other part of the standard. It's just a slightly different question that we are answering. We are not answering the question, has somebody declared it essential on that part of the standard? We are just answering the question, has it been found to be sufficient? Is it reading on that part of the standard? So in my view, it's just a slightly different question. Personally, I would prefer to have like reasonably good data that answers the second question instead of having to use data on the first question where everybody can just raise their hand and say, look, I have a patent that is declared on this standard. Nobody looks into it carefully, and it's just there. It's in the database. So that's basically what we are. And we know essentially that, as I said, only 1 in 5 patents has been assessed to be essential of those that have been declared as low as that.
Go for it, Rudy.
Yeah, thank you. And I would second you there. This is not the quest for the ultimate perfect data. And I think that's not what we'll be striving at. But we do kind of need to agree together what is the level of confidence that we need. If we want to go into any exercise, I think as well as the same case for any private licensing negotiation, you're never going to have perfect data, but you want to have a degree of confidence that you can base your decisions on and your conclusions, etc. And I think we're together in the process of finding out where is that level of confidence. That's something we try to do with the pilot study for the European Commission. How reliable is that outcome? There is no golden standard, there's no absolute perfect data, but it has to be having enough confidence basically to give all the different people on the table confidence. I want to get into that. I'm willing to enter into a deal on the basis of this particular data and set of assumptions that we're sharing here. It might be perfect, but it's good enough of an approximation of the actual situation. And this we have to find out together, find out how this database can play a role, find out how AI can play a role. I'm still a strong believer that we need a reference set at least to test all the other alternatives. So I think we're going to need manual assessments as well, basically, at least as a reference point to understand what we're doing here. But yeah, this is not about perfect data. Yeah.
And that was not the point. I think this is progress. The point here is that, and proof is in the pudding, right? Like there was a lot of discussion about valuation models in the past. And do we use valuation models to come up with the value of a patent? No. So I view this exercise as an important one to try to take an ocean and reduce it to a pool where you're more likely to find the most relevant things, but that's what it is.
Benno's got a quick comment.
I think I can add to this as well that I tend to use the term pragmatic transparency. Again, remember, when we talk about this and we get into the trenches, it sounds almost like this can't possibly work. We don't have the information. Nobody can negotiate. Yet, there's more subscriptions for cellular than there are human beings on the planet. So it is working somehow, right? So, and maybe that's the research question. Why is it working so well, given that it looks like it should be more difficult? And so we can improve on all these things, but transparency is what is the minimum amount of information required for actors to make a deal? That's all that's needed. The rest of it is just researchers getting excited about data and looking for perfection in something where it's not objectively possible to measure, just like patent validity is subjective. It's all subjective, so we need to come to a place where we can make the market work efficiently, which it already does very well. And how do we improve on that without making it worse, right?
Go, Bernard. Yeah.
Let me use this opportunity to bring in a bit more of economics here, maybe, given that we are so many economists here. And actually to cheer what Justus has done just a few years ago, so to say, because Justus was tasked to ask a question, and the question was, is it efficient for us to bring in, to use, basically to develop a system that allows us to have more essentiality information at our fingertips, right? And at a very high level, what you need to do to answer that question is to ask you, what is the value if we have transactions that are more efficiently because we have additional information, and how much does it cost us to generate that information and disseminate it? That is actually what you need to do, right? And Justus, played through a few scenarios and came out with, I would say, like a so-so type of result, like not clear cut, but things have moved on, and this is the important. There's two things here. First one is actually there's a few more things that one should add to that equation that haven't been added in that report. But that's how our understanding evolves. And then there's a second aspect, and that's the one that I mentioned on AI, because the technology has just become so much cheaper, right? And so we need to basically reopen this and ask ourselves, well, we have new developments in the equation. Is it now worthwhile? And that's basically the question that needs to be answered, hopefully rather sooner than later.
Yeah, Rudy.
Okay, that's a super interesting discussion and many things to follow up upon, but I would like to add one new dimension to the discussion as well, which I don't think had attention here yet, and that is the global dimension. And I specifically want to talk about this also in the effort that we've been done today, because what EPO has been doing started more than 10 years ago, collecting this type of data and using it for prior art data, and the fact that we can use it here. This is being established by the Board of Appeals. That's very clear when we Europe this. But this is unique. The rest of the world doesn't do it this way. In the rest of the world, in most countries, basically, this data, this prior art from standard setting is basically not allowed to be used for prior art. There's all type of interesting possible consequences of that. One of them is forum shopping. People might want to apply for a patent in one place or another. The coverage of the patent might be different. Might also be a movement of other officers also looking at what the EPO is doing there. So there's not one single question on the table, but I think the global dimension is also very important here, because this is not only a unique data set, but it's also related to a unique type of policy, how EPO is using this SDO data. And I would like to put that on the agenda as well as in terms of awareness. This global dimension is important here.
But I'll come to you, Perry. You've heard quite a lot. Let's see if you've got any comments on what you've heard so far before we're starting to run out of time, and we will start to take some questions. But perhaps if there's anything you want to say.
No, the main comment is that thank you for valuing the efforts and the data set, and I agree with all the words of caution that as we say, that's a data set that establishes link between patents and standards through examiner citations, and that's what it is. I think it's different from what we had out there, in the sense that this is not based on self-declarations of essentiality, right? So it's based on an examiner assessing whether claims in the patents are related to standard documentation and text in a standard document. And then the use cases are many, I believe, but this has to be approached with caution. As for the essentiality checks, agreed with all that has been said. I think this offers potential. Why? Well, because it's a data set at the patent standards level already, right? So it does combine pairwise information, and that's what you need to going down at this type of analysis. It could be helpful. There's many things to consider. Rudy has mentioned the different types of citations, X, Y citations, which could be blocking and therefore kill essentiality for the citing patent. I think that these are also probably the patents, my feeling is, that could be closer to essentiality for the same reason that there's some text in the patent that's very close to text in the standards, to the point that some of it is blocking, but some of it might not be blocking. But again, that's where some of the interesting margins, and it's getting very technical, but thank you for the discussion, very high level.
Yeah. There's a couple of things I want to pick up, and I'm going to come to you, Kurti, just quickly, to get a bit of an idea of transparency around patent pools and bilateral licensing. I wonder if you can just bring that in. I'm slightly nervous towards the end, but if you can give us a quick comment.
Yeah. Tell me how many minutes we have. I will be concise accordingly.
And I'll be very grateful.
Okay, very quickly, patent pools are a helpful mechanism, as we know, to bring multiple licensors' portfolios together and be able to be a one-stop shop for licensees. There are limitations because, let's talk about some very famous patent pools like Avanshi and Syswell and Via Licensing that have seen quite a bit of success. They have been successful to some extent, and to some other extent, there remain challenges. The primary one being that how do you try to divide the licensing revenue across different licensors or patent owners who aren't similarly situated. And because of that, in the past, patent pools that have uniform or patent holders that are similarly situated have been far more successful, because it's hard for coming up with an agreement to divide the pie of revenues. That's sort of a continued challenge, I think, that we will see, and we will have to. The pools have to basically work through that. Other challenges include, questions around regulatory, antitrust concerns, transparency, but I think those have been more or less resolved to a large extent, and Avanshi's success in the auto space is quite commendable.
Now I'll come to you, Bowman, just quickly. If you can talk to us a little bit about the collective action problem and ways to resolve that. I know it's another big topic, but we can just bring it in quickly.
Sure. So, I mean, for things to work out in the ecosystem, you would want for something to be FRAND, right, to be fair and non-discriminatory. People need to pay, implementers need to pay at the same time for their own sake, because if some implementers pay early and some pay late, then it's not fair. That is discrimination. So, and this becomes a big problem, because if why would you want to pay a royalty and create a higher cost for your product when your competitors are not? So this stops everyone from wanting to pay until everybody's paid. So mechanisms like patent pools or platforms that can bring together both buyers and sellers, licensors and licensees, or even well-designed, I'll add that caveat, well-designed license negotiation groups, can also solve this problem, because you can gather everyone together to pay at the same time. And so these types of mechanisms, they flip around the transparency issue as well, right? Because transparency, if you have all the patent holders in a patent pool, or you build these platforms, then the transparency issue is an issue about compensation amongst the licensors. It's not an issue of, do we know we have all the SEPs for the licensees anymore. So these collective mechanisms flip around everything, So the whole issue of transparency for licensees goes away if you create patent pools and other collective organizations in a good way, which we see in many instances. It's very interesting.
Yeah, I would love to chime in here, right? Because now we have focused on two questions. One is basically, are patent pools simplifying things? And then secondly, do we have this collective action problem? And let me now, basically, in the spirit of trying to be a bit optimistic and driving dynamism. So, these are attempts to make, if you want, certain transactions slightly more efficient, right? To one way or another. Or these are basically problems that are arising if people think that they're not paying a fair price. Like this collective action problem is basically everybody thinks that the price is unfair, it's too high. I don't want to pay a too high price. I only want to pay a high price if everybody of my competitors is paying a high price as well. My reaction to that would be, let's approach it the other way around. I mean, if we have a fair price, then this whole question is moot. Actually, like for example, if I go to a fast food restaurant, right, I know the price in advance. I know that the price is fair, and I don't care whether Rudy has already eaten in that restaurant or Pere. I just go there, think I pay a fair price that I know that's transparent, and I am done. It's very quick, right? And I think that's basically where we need to go with SEP licensing, right? We want to have quick transactions, right? We want to have a transparent market where we can efficiently transact, and then we don't need to bother about these questions of whether basically I'm only wanting to eat if Rudy and Pere have already eaten.
The problem is with the fast food is that you've already eaten the Big Mac, you just haven't paid for it, and now you're already full, and now you don't want to pay if everyone else hasn't paid.
Ja, ich muss gleich einen Vortrag halten oder halt Panel. Ich rufe ihn zurück. Cool. Schickst du mir noch einen Slack mit der Nummer und so? Ja, cool.
Sorry, Gail. That means sort of that our time is starting to come to an end, and clear that we will try and get some questions. Just a couple of minutes of questions now. Okay, we've got some in the room. Yeah, let's go for in the room to start with. I will come down to you. Put your hands up if you've got a question. Okay, that's good. Let's take two quickly. We're going to be super quick. You're going to ask a very direct question. I'm going to hold the microphone.
Thank you. I'm Matt Noble, Bud and Bud. So I'm interested in the discussion of AI tools to judge essentiality. As a practitioner, we're being pitched, literally weekly for tools that claim to be able to do this. But the problem is that, unlike some people believe, most patents aren't actually declared to a specific part of the standard, right? A minority of patents actually flag which part of the standard they declare to, right? So without something like that, or something like Rudy's talking about with an essentiality standard, the amount of money you'd need to throw at these tools to get them to judge essentiality is, we judged it was about $2 million per run. So, I mean, does that affect the confidence that we have that AI is going to swoop in and save the day on this one?
I'm firstly going to ask your name as well.
Matthew Noble, Bud and Bud.
Do you want Rudy to answer that question, or who?
Yeah, sure. If the two people, gentlemen, Benner and Rudy, could answer, that'd be great.
I'll come to you in a second, Rudy. We'll take the next question, sir.
Thank you. Edmund Mangold, BMW Group. I took from the discussion that the data set is very helpful in the patent application phase to figure out prior art, but it cannot replace an essentiality check, which would be for the future standard, mapping the features of the patent and the future standard. So from that perspective, to my understanding, what the proposed regulation would be goes in a different direction than this data set, or the data set cannot replace the regulation. And just another question, maybe for the others as well. The sample concept of the regulation, checking only samples from time to time, from a statistical and commercial perspective, can that help more than the data sets?
Okay, let's start with you, Rudy.
Okay, thank you. So using AI for this, I mean, obviously there's a big promise there of AI. We can do a lot of interesting stuff. There are discussions, and I also have my own views on this. What are the maybe inherent limitations using AI there? But there are two things I would like to emphasize. First, I would not have any trust in AI if we can't objectively test how well it is performing. Once we have a reference set, and then I'm happy for everybody to apply for an AI mechanism, we see how they perform on a predicting set, etc., and then we can draw conclusions on that. The second thing is that it's great to have a lot of different efforts over AI, but having 20 different AI mechanisms coming with different outputs maybe might create more noise than we're already having here. So we probably want to be a little bit careful about what we wish and whether we want to have so many different AI, different type of initiatives there. So let me leave it at that now. That was the AI question.
Dano, you wanted to jump in.
Yes, I want to jump in on sampling, but I do also have a comment on AI. I mean, on AI, the point is it's all about, the dynamics, if you want, right? Like the cost of running certain analysis is coming down at an incredible speed. And I think that's, of course, something we need to factor into our equation. And, and we are living in a dynamic system, if you want. And I mean, you need to identify the moment when it's just efficient, if you want to start tapping that technology, right? All we're saying is basically, well, there's wonderful technology. Let's use it if efficient. That's basically what we're saying. And then on the sampling, and that ties in actually quite neatly, because sampling is something that is done to bring down cost, right? So we're not testing the entire stack. We are just in a smart way, pulling a sample, and that's also something Justus looked at back then. And this helps us bringing down the cost. And we need to do that because each and every manual review is costly, so we want to bring down the cost. Now, that can be useful, especially if you have large portfolios, and if basically the basic question is, I want to license that portfolio, I'm not interested in whether that patent is essential. I'm interested in what's the share of patents in that portfolio that is essential. And then sampling can be really a good tool. One more sentence. But then, of course, as we get to more efficient technologies on essentiality testing that are cheaper, if you want, we may not have to rely that much on sampling anymore. So sampling is good, but we may not need it anymore in the future.
I have no problem with having to stop people, by the way. I enjoy this. This has been a wonderful discussion. Let's move to Curti quickly, if you want to pick up on any of the questions that were just asked there.
Just quickly to, touch upon Matt's question, I thought that's exactly the use case for a data set like this, where you can, I think the analogy was, it's so expensive to look at the entire data set, but if you can use some of these tools to come up with a smaller subset, like a pool, where you're much more likely to find potentially essential patents, then you're able to do these assessments in a way that is much cheaper than currently, Matt. And you may not even need to do that depending on what the use case is, right? Like if you're really just trying to establish general essentiality of a portfolio, it's different, and that may be enough, versus if you're trying to establish the true essentiality of a certain handful of patents, you may want to have a technical expert. That's ultimately looking at the claims and the standard charting.
Bowman, a final comment from you before we wrap this panel up.
Yeah, I could just say that you have to ask the question, why are you doing this, right? Sometimes I think we're trying to solve transparency on too deep of a level, right? That's why I talk about pragmatic transparency. What are you trying to achieve? And you need to know enough about who are the licensors, who own the patents, what is the rough amount of aggregate royalty that you have to have in order to be able to predict. There are people that can help you. There's companies out there now that have a very good. We did a study at Law Network with my colleague Lou Zaretsky, where we looked at like 12 different studies, and they all come up with different answers. So there is no one answer. So I mean, if we did what Rudy said and only allowed one AI system, then we would only have one answer. But if we allowed more, we would get more answers, because there are more answers. There is no ultimate answer. So what you're going to get is an aggregate understanding, and is that good enough to solve the problem that you have? And the answer so far is yes, because it's all been very successful so far. Can it be improved? Definitely. But we only need to go as far as necessary for business purposes.
Okay, thank you so much. Thank you to Bowman and to Curti, who've joined us online. And a big thanks to the gentleman on stage as well. Can we have a round of applause? Thank you so much. I'll ask you guys to take off the stage, leave your microphones on the chairs. Really nice way to start. And now we're going to move directly on to our next presentation. Our next session 2, is recent developments in European SEP case law. Justus has already been spoken about quite a few times on the stage today, so it's a good moment to bring you up. Justus Baron is the Director of Brailer and Research Director. He's also at Northwestern University Centre on Law, Business and Economics. We're going to have a 10-minute presentation from you on your study on European SEP case law. So please, thank you so much. A round of applause for Justus.
Yeah. Thank you very much. Thank you very much also to the European Patent Office for having me here today, and for giving me the opportunity to contribute together with my team to the study in some capacity. So I believe that in this audience, in this room, I do not need to explain much, that standards are intended to be widely used. At the same time, some of the most widely used standards include technology that is covered by patents that are owned by many different companies. So this leads to a need for licensing. And by and large, most of these licenses are agreed upon in bilateral or multilateral negotiations. But obviously, disputes can happen and do happen and they may involve disagreements over a variety of issues, typically involving technical issues such as essentiality, validity, infringement, or just simply commercial issues, the value of FRAND licensing terms to SEP portfolios. Now, over the last 10 years, when it comes to the situation in Europe, there has been a guiding framework to some parts of these disputes, which is obviously the European Court of Justice's Huawei versus ZTE decision. And most of litigation in Europe has largely focused on SEP holders for requests for injunctions, and were dealt with under this framework. But obviously this framework does not deal with all aspects of SEP litigation, and it has been applied differently in different countries. And furthermore, there is a new element, as we have already heard various times today. There is a unified patent court since June 2023, which offers a new venue, a venue that promises uniform, specialized, and efficient framework for patent litigation at European level. And as we will see in a minute, this new venue is particularly relevant and attractive for SEP cases. So it is against this backdrop that Michael Fröhlich and Pere Castells approached us and suggested that we collaborate on a descriptive study of SEP litigation as it has been going on in Europe in the past, in particular with a focus on the UPC and the role that it might take place. So I had already done some prior work trying to just describe SEP litigation in Germany, so I was already quite keenly aware of the multitude of challenges with this exercise. So as we have heard, we do not have at present a comprehensive register of essential patents. We do not even have a register of all potential SEPs for all the different standards and standards organizations. And in Europe, we do not have publicly available data on all the patent litigations that is going on. So it's very difficult to just comprehensively observe and describe SEP litigation because it sits really at the interface between these two different populations which are difficult to observe and describe. And on top of that, we are trying here to describe a reality that is very heterogeneous. We have different countries with different procedures. So what is called a case in one country is very different from what's called a case in another country, making it very difficult to consistently describe and just compare the extent and magnitude of litigation activity that we see. And we obviously will never observe the full universe of everything that is going on, in particular with respect to litigations that settle or are withdrawn before a court decides. And all this taken together leads us to look for one possible way of trying to put some consistency in this, try to give some modest measure of transparency by creating a unit of observation that actually makes sense for these cross-jurisdictional comparisons. And so we have focused on what we call the disputes. So disputes is not the legal definition of a case, it's not a decision, it's basically the relationship between two parties that are in one or multiple litigations which we think is related and which we think is all leading to the same licensing agreement or not. And this in itself is also challenging because these parties that are involved in these different litigations in different jurisdictions, they are themselves complex parties because corporate structures are complex and not always super transparent, and they are dynamic over time. So all this is very challenging to describe and observe. But we think we have done, with limited means, we have done a reasonable effort, good faith effort. We have looked at and compiled approximately 1,000 decisions post-Huawei ZTE, orders and decisions of all kinds of types, including management issues, like case management issues, including revocation orders. So it's not limited to final court orders. And in this data, we have then identified 102 SEP disputes following our definition of dispute. And just to give you a really quick sense of the population that we observe, so I don't think it comes as a surprise that SEP litigation in Europe has primarily taken place in Germany and the UK. And then in the very recent past, we have seen the emergence of the UPC. So we have 102 disputes over the last 10 years, and then just since June 2023, we have observed 23 different SEP-related disputes that have reached the UPC. Obviously, we have a slight difference of methodology here, which is that the UPC is much more transparent than the national courts when it comes to orders and decisions, so we have a much more comprehensive database to work with. So here we do have data on cases that are still pending, and we have data on cases that have settled or were withdrawn. So these numbers are not directly comparable, but we do have, as we also heard from Mr. Grabinski, we do have substantial decisions already coming out of the UPC, and if some of these cases that are currently pending also move on to decision, then this definitely looks like the UPC is taking a significant place as one of the significant venues in Europe for SCP litigation. Where we have a little bit more of a solid handle, a solid grip on the data is within the UPC, inside the UPC. And here what we can say with good confidence is that SCP-related disputes take a very large share of the UPC's caseload. So just focusing on the UPC, we have observed 271 infringement actions filed until March 2025. We have heard earlier that this number has already exceeded 300 by now. And using our methodology, we aggregate this to 194 disputes. Out of these, 23 are SEP-related, so 12% roughly are SEP-related, and they relate to 73 different infringement actions, which corresponds to 27% of the infringement actions that we observe. If we take the full universe of orders and decisions at the UPC that were registered until March 2025, we saw that there were 894 orders and decisions, including 171 that were, 123, excuse me, that were related to SEPs. So this is 14% of all orders and decisions, which one has to put into perspective with the share of SEPs in the population of European patents, which hovers somewhere around the 2%. So it's definitely, these patents are very well represented at the UPC in terms of litigation activity. So we can also look at the number of asserted patents, and here we see the same picture. ETSI-declared SEPs account for 8.6% of the patents that are asserted at the UPC, but account for less than 2% of the patents in the population of EPs. Video codec patents, there are 6 patents, and then other potential SEPs. As we heard, there are many SDOs for which we don't have these SEP databases, so we can only say that there are, on top of all this, there are still other SEPs as well. So this SEP-related activity at the UPC is quite concentrated geographically in the Germany-based local divisions of the UPC. That is true for patent litigation at the UPC in general, but it is particularly true for SEPs. So right now, 95% of the SEP-related orders and decisions that we have identified were issued by one of the local divisions of the UPC based in Germany, which is much higher than what we observe for non-SEP-related orders and disputes. And it's the local division in Munich is generally the local division that has issued the largest number of orders and decisions. That is also true for SEPs. And the local division in Mannheim is actually the only local division of the UPC that we observe where the majority of orders and decisions was related to SEP-related disputes. And one thing that the EPO was particularly interested in, and rightly so, is the potential that the UPC has to bring some degree of harmonization into what has previously been a fragmented landscape of patent litigation and SEP litigation in Europe. So there are multiple dimensions and notions of heterogeneity or fragmentation, but one of these is what we here call parallel litigation. So parallel litigation could mean in a narrow sense that the same patent is being litigated in different courts, but here we take a broader perspective, which is basically that the same commercial dispute leads to litigation in different jurisdictions. And this has been the case roughly for 20% of the disputes that we have observed in Europe over the last 10 years. So here, one word of basically to put it into perspective, is that over the last 5 to 6 years, almost all of these parallel disputes that we observe involved the UK in one way or another. So it's parallel litigation between one EU-based court and a UK court. And as we know, The UK does not participate in the UPC, so the UPC does not eliminate the potential for parallel litigation, but the UPC has been actively involved in most or almost all of the recent cross-border disputes, meaning that it is taking the place that was previously occupied by different courts from different member states of the EU, and so at least in this respect offers some prospect for greater harmonization. On top of course, of the greater picture of harmonization, which is that different disputes are decided by a single court under a single procedure, which, as we have seen with all this significant amount of heterogeneity between disputes, might just improve transparency and comparability in SEP litigation in Europe much more generally. So with this, I thank you very much for your attention, and once again, I would like to thank Michael and Peter for confidence in us and working together on this study. It has been a great pleasure, and I'm looking forward to comments and reaction.
Thank you so much, Justus. Yeah, you'll have to sit down there because we have three. If you sit in the front row, actually, if that's okay. I'm sorry, we don't have enough seats. But keep your microphone, and I'm going to invite our three in-person panelists up with us. Hold on to it. We'll give it to the people at the back. So if I can ask our panelists, I can't see where they are. There they are. So we have 5 people to talk through this. Firstly, Rianne Colden, who's the presiding judge of the second panel of the Court of Appeal of the Unified Patent Court. Please come and join us on stage. Yep, round of applause. We have Nathalie Sabotier, who, she's back there hiding, who's a judge in the Court of Cassation in France. We've got another chair. Wonderful. Thank you. No, please come and join us. Sorry. Yep, a round of applause for Nathalie. Online we have, we've got him, Richard Mead, who's a judge in the High Court of England and Wales. And, we have Georg Baumann, who's a judge in the Higher Regional Court of Munich. He's in person with us. And last but not least, online, we have Georg Picht, who's a professor of commercial and business law at the University of Zurich and a fellow of the Max Planck Institute for Innovation and Competition. Wonderful. We are really tight on time, and we have lots to get through. Let's start with you. But just to say, we've all agreed on first name terms in this instance. Obviously, our panelists are judges. But let's talk to you, Rianne. Let's start there. The UPC is a new court for patent cases, we've just heard, in Europe. Considering that it was set up to deal with patent disputes, do you think that the UPC could consider setting a specific FRAND rate, considering the competition law and contract law aspects associated with all of that? Perhaps you can give us a bit of an overview of that. You might have to flick it on. There we go. Yeah, the bottom one there. Oh, yeah. Other way. Okay. Done.
Sorry, this shows my technical expertise. Well, first of all, I have to say I'm at the Court of Appeal level, as you already said, and we haven't had the opportunity to deal with an SEP case at our court yet, which makes it a bit difficult for me to sort of elaborate on our UPC case law. But of course, we all know we have a lot of cases pending at the moment. We have some decisions. They haven't come up because they settled. So there we didn't have an opportunity. We did have some procedural appeals, mainly on disclosure of documents and some on confidentiality. And those are typically orders that happen a lot at the Court of First Instance, and that may also explain that there's a lot of orders going on in the Court of First Instance that are obviously SEP related, but they count as orders, but I wouldn't call them, don't confuse them with cases as such. Having said that, yes, there has been some discussion about whether the UPC is a forum for SEPs in view of the contractual competition law nature, whereas our court is supposed to deal with patent disputes. Now, the Court of First Instance in Mannheim has been quite explicit in saying that under our agreement there is this possibility to raise a counterclaim and a defense for license setting, and the Court of First Instance has said this also goes for not yet existing licenses, but also to have a license set. And there's also been a suggestion in the literature that the UPC, just like the UK courts, could actually, in infringement cases and in the mirror also, I would think in declaration of non-infringement cases, deal with conditional judgments. So an SEP holder could start an infringement case and ask for a conditional injunction, which is an injunction if the implementer would not be willing to enter into a license agreement on certain reasonable terms. So in the mirror situation, the implementer would come to court and say, please could you declare I'm not infringing this particular SEP patent because I'm paying the reasonable royalty that you, court, please set for us. And that seems to me, well, I've looked at it. I can't see any reason why that shouldn't work with our court, similar as it has been done in the UK. So I think that's a proper suggestion. So, yeah, if that answers your question.
Yeah, I mean, it's a really, it's a great start to our panel, and there's a lot of interest in what the UPC is thinking. Let's talk. I mean, one of the great things that we can do on this panel is look into different jurisdictions, and let's start with you, Natalie. Perhaps you can walk us through the approach in France to resolving FRAND and SEP disputes. How does it, what's the overview and the current sort of barometer of what you're doing?
We had both type of cases. We tend to divide the world between those who deliver injunctions and those who deal with contractual cases, and we did both of that. We had a few infringement cases that were related to essential patents, and all those cases ended. We didn't set a FRAND rate as requested by the patent owner because in some cases the patent was invalid and in other cases the patent was not essential. And we also had, as you know, claims based on the ETSI agreement, the ETSI statute, with a claim against or with ETSI. I don't know how I can handle it. And all those cases were related to the basis of the statute, which is stipulation pour autrui, based on French law. And all those cases, all the parties settled after we declared we had jurisdiction to deal with those cases. And we had also, so maybe France is an incentive to settle agreement, I don't know. And we also had one case based on a violation of the Article 102 of the Treaty on the EU functioning. And as far as I know, this case also led to an agreement between the parties. And I think I made a pretty close picture to the cases we had so far in the FRAND-related disputes.
Yeah. Let's move to England and Wales. Let's bring in Richard Mead, who's joining us online. Perhaps you can talk us through the approach in English and Welsh courts in this area. Where does the case law lead you?
Yes, am I all right for my 3 minutes, Nicholas? I've got slightly longer remarks than the two previous speakers, but I will move quickly.
Go for it. I'll come in if we need to. Yeah.
Okay, so well, first of all, thank you very much for having me. There's a tremendous amount of UK case law over the last 20 years, and a lot that's recent. But I'll provide a very, very quick summary as context for some other remarks. Our case law comes from 4 places really. One is just the standard law of patent infringement and validity. There's nothing really special to say about that in the FRAND context. The second is tailor-made remedies that we've created as a matter of English law, because the English courts have an extensive general and inherent jurisdiction, and we're not limited to remedies that are written down in black and white in a code. And that's included declarations about essentiality, and importantly, declarations about what a global FRAND rate will be, which will be familiar to the audience, I'm sure. We have the FRAND injunction, which is very similar to what I think Rian was mentioning a short while ago. We grant injunctions that if there's a valid and infringed patent, that the implementer is injuncted until they take a FRAND license. We also, thirdly, look to competition law. Huawei and ZTE is still a big part of our analysis, although, of course, it's some years old now and came to the Court of Justice in a very different litigation and commercial milieu. So perhaps that'll be looked at again. And if it is, even though we're not in the EU, we will be very interested to see what the Court of Justice says. And fourthly, a lot of our case law is based on the ETSI contract, which Nathalie Sabotier's already mentioned. And a lot of our case law is based on the recognition that an implementer, at least in the first instance, has a potential contractual right to be offered a license to SEPs. So if I just touch on a few of those and their significance, we take the view that the patentee can't get any relief for patent infringement until there's been a patent that's found to be valid and infringed. And infringed in this context, of course, nearly always implies that it's essential. But we also recognise that with the larger portfolios that are being litigated in these cases, it's inevitable that there will sooner or later be a finding that there's at least one patent that's valid and infringed. And so our recent case law, based on our case management powers, our general powers to manage our lists, has taken the view that we will assess the FRAND rate first. We can't grant an injunction at that stage because there won't have been a patent found to be valid and infringed. But we take the view that the real dispute in these bits of litigation is the price. And so our recent case law has trended very heavily towards doing that early. We split the proceedings into a number of trials and we try to do the FRAND rate quickly, either by the agreement of the parties, or if the parties don't agree, we make a decision ourselves. Secondly, we've taken the view that we grant a FRAND injunction that I've mentioned already, and that the implementer does not automatically lose their right to a license if historically they've been unwilling for one reason or another. But at the point when the court reaches a decision, they are then willing to commit to take a license on terms that the court decides. And we reached that decision in a case called Optis and Apple Trial F, which I decided and which went to the Court of Appeal. And the basis for that was that it was contrary to the ETSI IPR policy to lock people out of the standard, because the ETSI IPR policy is to promote broad usage of the standard. And we also said, I said, and the Court of Appeal agreed, that injuncting implementers who were willing to pay was likely to lead to their having to pay supra-FRAND rates. And that's been a feature of another aspect of our recent case law, which I'm not going to go into in any detail, although it's very topical. There's not enough time, and that's the issue of interim licenses. I mean, I'll be happy to take questions on it later, but there's not time to cover it now. And then lastly, again, there's no time to go into the detail of it, but we have had a lot of decisions, 2 recent Court of Appeal decisions on the actual valuation exercise, where, as matters have turned out, predictably, I think, we've decided that comparables are the best approach. They're not the only approach. We use top-down approaches as well, but comparables have been endorsed. I think some people have said they're not the best, they're just the least worst, but in any event, they're at the forefront of our valuation exercises at the moment. So there you are, 20 years of case law in I hope about 3 minutes, and I'll be glad to take any questions or participate in the discussion.
Yeah, we're aware that this particular panel is very difficult because the need to sort of expand is always there. But really grateful for how concise you were, Richard. Thank you, and for everyone. Let's come down to you, Gail Baumann. Let's talk a little bit, like, having in mind the amicus brief from DG Competition. We've talked a little bit about Huawei versus ZTE. And perhaps you can talk about how formulistic, how flexible courts need to be around this, having that all in mind. How do you do it in Germany? What's the thinking?
Well, in the view of in the Commission's view and the European Commission's view, the URY program is a sequence of steps the parties strictly have to adhere to, and the court has to when examining the FRAND objection. And if one step has failed in the opinion of in the Commission's opinion, the party who committed the error is out, and the action is automatically has to be dismissed, or the FRAND objection has to be rejected. In Germany, the Federal Court of Justice, the German Supreme Court, didn't interpret the URY program in that way, I think. In the decision Haya Siswell from the year 2020, the court focused on the question whether the patent user could be seen as willing to license, and he single steps, but took an overall view about all the circumstances of the individual case. And in my opinion, and as our court stated in the decision issued in March of this year, the URY program...
Connection, Richard.
You can't hear me?
They'll fix it. Please carry on. Okay.
The URY program is not a sequence of steps the parties strictly have to adhere to. We think the idea of URY was that the parties should enter into negotiations to find an agreement. And for that, a corset of steps is not necessary, and I think it's not useful or helpful. And another aspect is the principle of good faith. The European Court of Justice mentioned that principle also in the URY decision. And we think, our court thinks that it would not be in accordance with good faith. For example, if one party could claim that one of the first steps was formally not correct at the very beginning of the negotiations, if or when the party afterwards has entered into negotiations with the other party. So to answer your question, I think the URY program is a framework, it's a guideline, it's an important guideline, and the parties in principle or has to adhere to the steps in principle, but it must remain a flexible system for the parties as well as for the courts.
Thanks. Let's bring in Georg Picht, who's joining us online as well. Yeah, he can hear us. Wonderful. Let's talk a little bit about willingness. Is it potentially sort of maybe distracting from some of the real issues, maybe, or is there no difference in outcome whether FRAND is sort of understood as an antitrust defence with its focus on willingness, or as a contractual defence, which seems to focus more on what terms are actually FRAND, or perhaps what the right price is? I wonder if you can talk to that and perhaps pick up on anything that you've heard so far. Georg.
Yeah, sure. So, sorry for being with you only online. You know, I think that already in the CJEU decision, you see, and this has become much clearer since then, that, you know, FRAND has essentially two prongs. It has a conduct prong, and it has a content prong. And the content prong is about the license conditions, and the conduct prong is about good faith negotiation conduct by the parties. And I think good FRAND decisions and good FRAND case law looks at both these prongs. And I think you have seen in the development of not least the case law from the German courts that willingness has become sort of the tool with which to gauge whether parties conduct negotiations in good faith. And this is why I don't think it is sort of an unnecessary part or something that would be irrelevant and distracting from the real cause at issue. Yes, the price tag matters a lot, and Richard has pointed this out just now, but it is also important to encourage the parties to negotiate in good faith, because after all, parties usually know best what market adequate FRAND rates are. So I think willingness has its place, while it should not prevent courts from looking into the price tag and the content issue either. When you look at the two ways, the contractual way and the competition law way, as a main basis for assessing FRAND cases, yes, I would say that apparently so far the contractual prong has invited courts more to go towards the price tag thing, whereas the antitrust, especially as handled by the German courts, the antitrust route has focused more on conduct issues and has been a bit more hesitant to come across with condition setting, defining of licenses. But personally, I do not think that this is inherent in either the contractual approach or the competition law approach, in the sense that you cannot do both under either approach. I think both approaches are fit to look at conduct and at content. It's a question of how you handle them. And as I read initial FRAND case law from the UPC, I find it really interesting and very promising, because it seems to try to combine the competition law approach that the CJEU, after all, has predominantly chosen, to combine this with flexibility as we have it, as we have known it maybe a bit more from contractual approaches so far. So it may be that the UPC brings about the perfect wedding of the strong parts of the competition law approach and of the contract approach.
Rian, let's come to you. I mean, this is one of the things. The setting of the FRAND rate is the big discussion. I mean, come in on what you've heard.
Well, what I would like to stress here, I think, yes, willingness is certainly an issue, but willingness is an issue on both sides. So, I mean, the willingness of the implementer that has attracted a lot of attention, I think, in German litigation so far, should not prevent looking at how willing the actual SEP holder is to offer a FRAND rate. So it has to be balanced both ways. And as to contractual and competition law elements, I think it has both, undoubtedly. The whole FRAND declaration was born from competition law issues. So without the FRAND declaration, you would have competition law issues with a standard. So undoubtedly, it has both aspects to it. But I don't think it really matters if you focus on the one or the other. The bottom line is, what needs to happen is that there has to be openness to the market on reasonable terms. And the parties normally would like to enter into an agreement. And I think, therefore, the focus should not be so much in injuncting or not injuncting. The focus should be on how to get those parties together. And that, I think, should be the focus in litigation. I have to stress, in our court, I'm not sure whether I understood Richard wrong by saying that they can just, do in the direction as the court likes. But in our court, I think that we can only deal with a case on the basis of a specific request. But for sure, we have a lot of case management powers for the judge rapporteur. So there can be an interim conference, and then to sort out what the parties' intentions are, and make sure that the right requests are on the table. And then the court has all the means, including transparency, having all the right documents, having the confidentiality regime on the table, and we have the PMAC later on, and then the court could enter into this rate setting for sure.
This is why you were nodding your head as the discussion was happening, because in France there's a slightly different perspective on this.
Yes, I don't. Just to say that I fully agree with Rian. The point is why this border between an injunction and a patent case and a contractual case. And that's where I think the Huawei Z2 case lead us to that result. This border between the two aspects. When the court, and I can mention it, we wrote it as a panel. The French court ruled it in a panel decision. Why the ECJ didn't want to allow us to take a look to the price, to the rate, while dealing with the injunction, when assessing that the patent owner is the best placed to know if its offer is FRAND or not. It means if its offer is non-discriminatory or not. I have an issue with that. And I think that when we are in a litigation, the judge is the best place to know if an offer is non-discriminatory, or not. And in that aspect, I think that maybe the will of the Commission is to put a little bit of a negotiation of a contract of a license, a real FRAND, and to reach an agreement and to set up the conditions to reach an agreement. And as a French user of the French law, which is applicable for Etsy, as you remind, to me, the amicus brief makes perfect sense. I interpret the will of the Commission as we want the parties to set up the condition to reach a fair contractual agreement. And I think we shouldn't see it as something, I hear bureaucracy and so on. Maybe we should elevate a little bit and see and take a look on the contractual aspect in the infringement and in the injunction cases. Yeah. That's my take on it.
I'm going to carry on with this panel. Thank you, Natalie. I'm going to carry on with this panel. I'm going to eat into the coffee break a little bit, and you're going to forgive me because we want to hear from Richard Mead. I want to bring you in on this from what you've heard, but we've also had a question on Slido from Richard Very, which is related to this, which says if SEP owners frame their request for relief in the UPC as a FRAND injunction, as Rian had suggested, does that make it less likely that the Court of Appeal will declare the SEP owner unwilling unless he or she gives a UK interim license? I wonder what you can make of that, and perhaps pick up on anything that you've heard as well.
Yeah, that's quite a complex question, and I wouldn't like to guess what the Court of Appeal are going to do. But I mean, the gist of the problem that the Court of Appeal has had with patentees' conduct is that when the litigation has come to a point where the implementer is willing to commit itself to take a rate determined by the court in a circumstance where the parties can't agree what the rate should be, the patentees shouldn't carry on seeking interlocutory injunctions in many countries of the world because they're going to get a FRAND rate. So if in continental or other litigation, or litigation in South America, which we're seeing quite a lot, if in that litigation the patentee said, we want an injunction unless you take a rate that the court determines, some court, that would be different. That would be substantively different. I mean, that's not what the patentees are doing at the moment. They're seeking unqualified injunctions in the other jurisdictions. So I think if there was that substantive difference, certainly it could make a difference, because the Court of Appeal's objections, as I've said, is about patentees who won't desist from seeking injunctions when a court set rate is available. Just on one other point, just of clarification, I probably wasn't very clear earlier, but to Rian's question, no UK court would ever say we're going to do the rate setting if the parties hadn't requested it. They will, one or other, or quite often both parties do request FRAND rate setting. And when that happens, and there's also infringement and validity claims, we case manage the sequence of those. But the UK court doesn't ever say that it's going to do FRAND rate setting off its own bat. That would be completely inconsistent with our approach. I mean, as Rian says, we eat what the parties put on our plate. So I hope that answers Richard's question and responds to that. Could I just say in relation to the antitrust contract discussion that is so interesting? It does seem to me that one has to at least think about the contract position. Huawei and ZTE tells us when a patentee can, without infringing competition law, seek an injunction, but it doesn't tell you the complete code. And an earlier comment this afternoon was to the effect that if one of the parties has acted unwillingly, they lose. Well, in the conduct-based decisions from the continent, especially from Germany, it's always been the implementer who's been found to be materially unwilling. But what if it's the other way around? I mean, what if a patentee at some stage was unwilling? Would one say, well, you can't have an injunction ever? You lose the utility of your patent? I don't think we would. I think what we'd say is you've got to be willing now, and you can demonstrate that willingness by agreeing to a court determination. So I think the fact that there is a contractual right to be offered a license is a critical part of the analysis. And I agree that it's a complex interaction and that both have their part to play. But I think they really do both have their part to play.
Rian's going to jump in on this quickly.
Yes, just one comment on this. I think from both perspectives, I mean, willingness is relevant at each stage. And the whole fact, as you say, I mean, if there is unwillingness at a certain stage, that doesn't prevent from that party sort of becoming willing at a later stage. And that willingness is never going to be irrelevant. Because under competition law, of course, it's going to be relevant. A willing party should be able to get the FRAND license, because otherwise you have a competition problem. But by the same token, I think the FRAND declaration under ETSI remains in place. So if you first don't like a license and then change your mind and want one, there isn't any reason why you shouldn't get one after all. And that's, I mean, I'm now talking personally. I have a bit of a problem with the Commission approach, saying if there is an unwilling implementer, that cannot be cured during proceedings. And I think that is a bit of a problematic approach. I think it could be cured, but what you have to ask is, what are the consequences if they change their mind at a very late stage? And there, you know, maybe like, you know, costs or, you know, interest on previously unused, unpaid for use can be put in place, not to lose the incentive to actually ask for one. But I think willingness will always be relevant at whatever stage.
Georg, I want to come to you. I want to bring in the issue around essentiality checks. How would you sort of look at that if an assessment by an independent third party would be litigated in your court? How do you see those issues?
Well, I think such a check would be very helpful for the court, but so far as the interpretation of the patent claims is concerned, I think the court will always have to assess it itself. It's the original responsibility of the court to answer such questions. As far as facts are concerned, in German law, it could maybe a kind of, we call it qualified submission, on which the other party has to respond in a substantive manner.
There's a lot going on.
I think it's helpful for the parties and for the court, but the courts cannot be bound on it.
Let's move to Georg Picht online and just bring in the UPC setting a FRAND rate. And is it limited to patent law matters, or can it also adjudicate issues relating to competition law or contract law from your perspective? If you can give us a relatively quick answer to wrap up our panel.
Yeah, thank you. I mean, I can chime in with what has been said before. I think there are certainly sufficient bases in the legal framework for the UPC that enable the UPC to hand down sort of a full-fledged FRAND decision catering to all or addressing all relevant settings here. We must not forget that the UPC is fully bound to European law, including European case law, and the initial FRAND decisions have made it very clear that they consider themselves to be bound by what the CJEU has said. And I think it would not be necessary from the legal framework point of view, and it would be really harmful for the beneficial potential of the UPC as a harmonizing court also on FRAND matters if we now started to sort of curtail what the UPC can do in terms of FRAND legislation. I think, yes, the UPC should be able to set rates, issue injunctions, and deal with contractual aspects of an SEP FRAND litigation, and deal with the competition law aspects of the SEP FRAND litigation. Always, of course, if you have as an anchor patent with unitary effect. So I think this must be the road forward, and I'm encouraged that, to my reading, the UPC and also to my hearing, the panel today does understand the court's role in such a comprehensive fashion.
Thank you so much. We're going to have to wrap it up there in the interest of time. I'm so sorry. I feel like we've scratched the surface. We want to go so much further. But a huge thank you to Richard and Georg that have joined us online. A huge thank you to our panelists here. Yeah, big round of applause. Before you head off for a coffee, I'm just going to ask my colleague from Euractiv, Dave Keating. He's going to tell us exactly what's going to happen in the second half after we come back from our coffee. You must please be back in your seats at 3:30. I'll just hand Dave the microphone.
Thanks a lot, Jack. I won't take up too much of your time. We do want to start right at 4:30. My name is Dave Keating. I'll be moderating the rest of the day. We're going to continue talking about these issues in panel 3. We'll be talking about alternative dispute resolution for SEPs. And then in panel 4, we're going to be talking about how all of these issues can help Europe's competitiveness. So we'll see you right back here in about 20 minutes for the next 2 panels. See you then.
Judge Toptiman, it's Nicola Dack. I think we're joining for the same panel.
Yeah, hello. Hi.
Hi there. Good morning. Or good afternoon. Sorry, I'm in the US. So I'm saying
Okay,
good
so
morning.
you're in the, yeah, no, here it's 4 p.m. So I'm almost done with the day.
Ah, that's good. Is there a nice cocktail reception at the end of the day, or something to look forward to, or is that a train journey back to home?
No, I'm actually back home because I don't have the time to do too much conference traveling. I've quite a heavy caseload at the moment at my division, and therefore I decided not to participate in person, but only to join in online to save the extra day traveling back and forth from Heidelberg, Germany.
Oh, that's great. I'm joining online for the same reason. I think it's great actually that we are able to join these conferences online, you know, to step out of your working day for an hour or whatever. Yeah.
Yeah.
It works really.
Yeah, but still, it makes a huge difference whether you can work a whole day or if you have a whole day with traveling. Even from my place, it were possible to go back and forth in one day even. Because there's the fast train, the TGV connection, which brings me from my home to the premises of the court in about 3.5 hours. But still, yeah. So it's more efficient to work back home. And of course, I always put proceedings first, and as we had quite a number of hearings and things to prepare, I had to decline to come in person.
I just think it's great that you're here online. Actually, I think I heard you speak, if I remember correctly, speak quite enthusiastically about the use of mediation and arbitration in one of the UPC cases I'm involved in. So it's nice to bring it to life at the conference.
Yeah. So hopefully the center will be set up anytime soon so that we can actually make use of the premises.
Look, I think it's going to be great. You know, one of the questions they've got for me today is, you know, do I think it's a good idea? I think it's a fabulous idea, especially on these FRAND disputes. Yeah.
Yeah. I think that for other disputes, it will be very individual cases where it makes sense. But I think for SEP it could really be an asset, and also the whole possibility to have this under the auspices of the court, so that the panel is still more or less in the back and may help also with certain kind of orders for confidentiality or for sharing documents or whatever. And that link you do not have very often while engaging in ADR proceedings.
Yeah, no, agreed. I think I suspect once it gets up and running, it could get very busy very quickly.
Yeah, Alesh would be very happy if he Otherwise, it would be maybe not that interesting. But we'll have to see what happens.
Yeah.
And where in the US are you at the moment?
I'm in our San Francisco office today. I'm actually looking out on the bay, and so I might move around so people can see. Yeah, I'm looking out on the bay in San Francisco, which is absolutely beautiful. It's very early in the morning. It's 24 minutes past 7 in the morning. Let me see if the camera reopens if I do that. No, I don't think it does. So yes, it's a beautiful morning in San Francisco.
Yeah, that's nice. I've been there
We'll find out.
Okay, welcome back, everyone. Hope you enjoyed the coffee break. We're going to start now with panel 3, where we'll be moving on from some of the issues that we already discussed in the first 2 panels. As I mentioned before, my name is Dave Keating. I'm another journalist based in Brussels. I'll be guiding us through these next 2 panels where we'll talk more about some of the issues that were already brought up today, but we'll expand them some more. And in particular, in the 4th panel, we'll talk about some of the real-world applications, how Europe can leverage its advancements in standards areas in order to increase competitiveness, which is a major item on the Brussels agenda these days. So we just heard in panel 2 about the recent developments in European Standard Essential Patent case law and the role of the Unified Patent Court in harmonizing Standard Essential Patent litigation in Europe. On this next panel, panel 3, we're going to talk about recent developments in European SEP case law with a particular focus on the role of the Unified Patent Court in harmonizing SEP litigation in Europe. We're going to start with a presentation of the Patent Mediation and Arbitration Center, which will start operating in the second half of 2025. It will play an important role in improving transparency and predictability in the licensing of SEPs. And so in our panel discussion, we're going to digest some of what we'll first hear in the presentation, and we'll get to hear perspectives on how the PMAC will complement the UPC and help improve alternative dispute resolution. We're going to start with a presentation from Aleš Zalar, who is the recently appointed director of the Patent Mediation and Arbitration Center of the Unified Patent Court, also former Justice Minister of Slovenia and a judge and president of the District Court in Slovenia previously. And I just want to remind you that you can ask your questions both for Aleš and for the panels to follow using the hashtag patentsstandards on slido.com. Aleš will also be able to answer your questions in the panel because he'll be on the panel afterwards. So Aleš, I turn it over to you.
So greetings to everybody. It's a great pleasure to be here. Great honor to speak in front of such a distinguished audience here in the room and online. Thanks to the organizer for providing me with this invitation. Yes, PMAC, Patent Mediation Arbitration Center, a startup, truly startup. We are in the process of designing everything from infrastructure to support staff, employment, and of course, regulatory framework. I will speak in following 10 minutes a little bit about what PMAC can offer, but before I start, and I will try? Yes. Before I start, I will just refer to the PMAC's scope of competence. I think it's important to know. Of course, PMAC is part of the UPC system. However, already the rules of operation of the PMAC provides the competence which goes beyond the exclusive competence of the UPC. So you see all kind of disputes which are linked with the European patent or European patent with a unitary effect, such as trademark issues, trade secrets, unfair competition issues. They could be referred to PMAC. That's important to know. The scope of competence, of course, is relevant in particular in arbitration proceedings, not so much in mediation. PMAC has no limit in terms of geographical scope. And the PMAC jurisdiction is definitely covering also the SEP and FRAND issues. And I will come back to this issue a little bit later. One important aspect of a PMAC, of course, it is that it is closely related to the UPC. The judges of that court have a duty to invite litigants to consider to refer their case to mediation, to arbitration, or any other appropriate dispute resolution which will be offered by the PMAC. Because PMAC will not offer just mediation and arbitration, but also expert determination, early neutral evaluation, which is again very interesting proceeding for litigants at the UPC, and hybrid processes, MEDAR, PARBMED, and similar. So that's one track where cases will come to the PMAC, but it's not the only one. PMAC is also a freestanding center. So the parties can always turn directly without having a pending litigated case at the UPC. And last but not least, not just the court, I mean the UPC, even some other institutions, competent authorities, including EPO, for example, in the opposition proceedings, not necessarily running in parallel with the proceeding at the UPC, could refer cases to the PMAC, or even national courts if national regulatory framework allow for that. As regards the SEPs and FRAND issues, we are now in the process of designing the procedural rules. Very, very important part. We are supposed to launch a very wide public consultation on these rules in this month. Mediation rules and arbitration rules will be the first. And one specifics in these rules, which might be of your interest in particular, is that we have in these rules envisaged a special chapter which regulates the specific aspects of SEPs and FRAND determinations. So, among other, the procedural rules allow so-called carving out the FRAND determination from the case which is pending at the UPC. There is some connectivity between the UPC and PMAC so that the parties in the proceedings at the PMAC could always ask the court to issue appropriate orders, and we heard about these orders in the previous session. Enforcement regime is another interesting aspect. Why? Because the consent arbitral awards and mediated settlements at the PMAC could be converted into the decision of the UPC and then enforced as any other decision of the UPC. This might be quite relevant for many litigants, but for those who are coming out of the Europe, let's say, it's important to note that, of course, for enforcement of arbitral awards, the New York Convention would apply. So you have two options here for arbitral awards: New York Convention or UPC decision if the award is based on a consent. Procedural rules are designed specifically for the IP disputes and patent disputes in particular. But as I said, there are some specific provisions envisaged in the rules concerning the FRAND. Some basic issues which you might be interested in. We will, of course, try to encourage litigants, disputants, to prefer e-mediation, if possible. There will be also financial incentive for this in terms of the fees. In arbitration, the initial conference will always be video conference. It's a mandatory. While the hearings, it depends. You know, the parties are masters of the procedure. If they want to meet in person, no problem. If not, even better. Language, again, the parties decide. There will be some specific procedures like expedited arbitration. We envisage also emergency arbitrator and so on, so on. So these are typical issues you find in many procedural rules also of other institutions. Now, as regards these SEPs and FRAND, there are several provisions in both procedural rules, and I would like to invite you all to contribute to the public consultation process. It will, when it will be launched this month, you will have 2 months to provide us with your feedback, with your comments, with your criticism, suggestions, whatever. Today we heard a lot of transparency. We start with transparency here, how we actually design the overall regulatory framework for the PMAC. So it's an open process, an interactive process. And as regards the SEPs, you can see in these slides what kind of issues could be addressed in the SEP FRAND, either mediation or arbitration, actually in both. Any patents that might be subject to cross-licensing, for example, claims and defenses, the conduct of proceedings in multiple stages, or any essentiality assessment. That's why we envisage also expert determination process as a separate set of procedure, which is designed particularly for this kind of situations. Determination of licensing terms and conditions, scope of royalties, and range of royalties. This is interesting. Setting the terms of an interim license pending a determination. We follow the development of the case law in UK, and we thought that maybe this might be an interesting offer to disputants at PMAC as well, so that the tribunal or the court, of course, could issue such orders. So it continues with the possibility that the methodology for calculating the FRAND royalty rate would be done within the alternative processes. And of course, as I said, the powers of the tribunal, of arbitral tribunal, or the UPC to issue appropriate orders, like order to produce evidence, confidentiality orders, or similar. Not just this, the confidentiality provisions are a little bit different than the general confidentiality provisions which govern mediation and arbitration proceedings. Different in terms that we envisage additional tools to be used by the parties, like confidentiality advisor, or the rule that only attorneys, could see confidential documents. This is in particular important for licenses. And then confidentiality order and non-disclosure agreements. So basically, we try to open the door as much as possible to future litigants. PMAC supposed to start operating in the early 2026. Most important, of course, is the selection process of the neutrals. And we already developed the criteria for selection of mediators, of arbitrators. And based on this, we will publish a public call for all who are interested to serve as accredited mediators or arbitrators at the PMAC. And then the expert committee, together with me as director, will make this selection process. We will check, of course, if the candidate complies with these requirements. These requirements are, I would say, wide enough on one side that because you never know what kind of expertise actually you need, not just technical expertise, but also other, financial, economic, whatever. But on the other side, of course, we need people with experience and reputation. We will search for neutrals not just in all 18 European member states which are signatories of the UPC agreement. We will search for neutrals also from all 5 continents. So from US, from China, from Japan, from Korea, because we expect that approximately 50% of disputants at PMAC would be from other regions and not from Europe. So you see, it's a big plan. Maybe somebody would say this is now a very interesting wish list, but we are working quite hard that this becomes a reality. And at the end of my intervention, I can say PMAC will try to keep 2 promises. The first promise is the promise of opportunity for disputants to select the appropriate process which would be tailored to their particular needs and interests. And the second promise we will definitely keep is the promise of process integrity. And that's why also your input is very important that when we finalize our overall regulatory framework. Thank you very much for your attention.
Thanks very much, Alice. So you can have a seat right there. And now, as you said, input is very important. So we're going to get some input now from our panelists who I'd like to welcome here on the stage. Now you guys can come up and take a seat. So we have here with us in person, Richard Very, a partner with Bird & Bird. We have Cordula Schumacher, who is a partner with Arnold Riss and formerly president of the European Patent Lawyers Association. We have Robin Jacob, who is a professor at the University College of London, and also for many years a barrister specializing in IP. And then joining us online, we have Peter Tochterman, who is a judge at the local division Mannheim of the Court of First Instance for the Unified Patent Court. And we have Nicola Dugg, who is a partner at Kirkland & Ellis International in the IP team there, advising on complex patent litigation, IP strategy, and FRAND and SEP disputes. So Peter Tochterman, I'd like to go to you first to get your reaction here. What are your thoughts on the evolution of the PMAC, as we've just heard laid out? And does it comport with your experience of what's going on with cases in Germany?
Yes, I will, but as I'm not in Paris, I take the liberty to send out some greetings in French at first. Bonjour, mesdames et messieurs, merci pour l'invitation. J'aurais vraiment naturellement préféré d'aller à Paris, mais malheureusement, mes 3 enfants m'ont passé tout assez fort et j'ai préféré de rester ici en bas de Heidelberg où j'habite pour éviter de vous passer la peste de mes enfants. Now I'm trying to switch back to English immediately, which sometimes is a bit of a difficulty for me, but I hope I'll do my best. First, before I start talking about the substance, I really have to express something. I'm really, really happy and thrilled that we hired such a passionate and enthusiastic director for the PMAC. I can really see what efforts are being done, and everyone will have to realize that there's pretty much work resting on the shoulders of our learned colleague and director Alesh, and that's something what I want to put up front before I make my humble suggestions and remarks here. So what can I say from my proceedings? I already was a presiding judge in the Panasonic Oppo cases, Panasonic Xiaomi cases, and now we received the last 10 new cases. We received in Mannheim, 8 out of 10 are SEP cases. And we already had settlement in SEP cases where we were able to support the parties in arriving at an amicable result by offering them a confidentiality regime by way of orders, or by allowing them to exchange certain documents like license agreements with third parties. And in already 2 cases, the parties very, very quickly, even in the course of the written procedures, arrived at an amicable solution of the conflict. And I think if we had the opportunities of the PMAC, and I get questions in quite a number of the proceedings already. So when is the PMAC operative, so that we can be referred to the services? I think that will be a very valuable tool to have this. And I think the special thing about the PMAC will be the fact that you have the ADR processes not as a standalone, but as ADR process under the auspices of the court. So, of course, we'll have no interrelations, no direct connections. So there will be no members of the panel who are in whatever way being involved in a mediation or in an arbitration. But still, while we may suggest as judge rapporteur or as the panel as a whole, the parties to go to whatever sort of ADR process, we can always try to help the parties if they wish our support, even while they are engaging in the mediation or arbitration with orders which may be of use for them to set the framework for successful negotiations. Another alternative, even if the parties will not end up finding a solution very early on in the proceedings, I envisage that we could make great use of the PMAC at least at the stage of the interim conference. So because there I believe that upon mandate of the panel, either the judge rapporteur or the panel as a whole may make suggestion to the parties to use to make use of the services of the PMAC, and already after having had a pre-deliberation on the case, at least highlight certain points which in the eyes of the panel may be decisive for the further dispute, and then tell them, okay, now you got at least some points of references where we believe there may be a problem on that end or at the other end, and take that with you, give it a try. Whenever you think mediation will lead you nowhere, we're always there. Get back to us, and we'll continue with the proceedings. But I can envisage that even in complicated and proceedings where we had year-long negotiations up front, which didn't lead to a deal, I think this could serve as a very useful tool. Thank you. That's my initial remark. Thank you very much.
Thanks a lot, Peter. Richard, let's turn to you next. So you have quite a lot of experience in mediation. What's your view on how the PMAC is evolving in the knowledge of the cases you've been involved in?
Sure. So it's both mediation and arbitration. The mediation that we were most recently involved in was the attempt between Nokia and Daimler and all of the tier one automotives to try and solve the problem that they had there. The big problem there was not just how much someone should pay for a license to the Nokia's portfolio, but who should pay. Should it be Daimler? Should it be one of its suppliers? Who should take the license? And when you've got this sort of complex multi-party problem like that, you can't solve that easily through litigation. It was much more easily solved through mediation, where you could get everybody in a room together, and you could look at Daimler and you could look at the tier ones and say, well, one of you's got to pay, so how are we going to figure this out between us all? So that was where mediation had a real advantage. Arbitration, we had a Nokia Samsung, we learned a lot of lessons from that, and then Nokia and LG, where I was on one side and Cyril, who's sitting there, was on the other. And we had a lovely 12 days in Paris, and I think actually it could have been an awful lot shorter if one of the advocates hadn't insisted on having quite so many slides. That's me, not Cyril. But we could do it much quicker. But the real important lesson from that was of simplicity. What in Nokia and Samsung, the big mistake we made was trying to agree a lump sum or trying to arbitrate a lump sum going forward, where you've got uncertain sales and big arguments about who's going to be selling what. With Nokia and LG, we kept it very clean. It was a simple per unit rate. There was no argument about sales going forward. And that meant the cost was about a third this time round. And the arbitration was much quicker and cleaner because you're arbitrating over a single variable. So the big lesson, I think, in all of this is try and find a thing to arbitrate that is as simple as possible, but gets as close as possible to solving the dispute.
Gyula, let's turn to you next. So you actually helped draft the PMAC rules. What's your reaction to the presentation we just heard from Alish? And do you think that the data suggests that mediation can work?
Yes, thank you. So we, as AppLaw, have been involved and have been happy to assist there with practical experiences on arbitration and mediation, or what type of rules we should see there. And in particular, I'm very happy that we have specific rules for SEP litigation. I think this could be quite a unique selling point for Europe, for the UPC, to have this combination of litigation, if necessary, but then also solving the dispute potentially through arbitration. And I think especially for SEP disputes, who tend to be very complex, we've heard the rate is usually at the heart of it, with the specific rules providing specific confidentiality regime, and also the possibility through the guidance of the court to just send, obviously with the consent of the parties, just some specific issues of the dispute to arbitration, the possibility of potentially parallel ongoing court proceedings on other issues, so not losing time there. So I think it's a real added benefit, and maybe not for all cases, but for some cases it can make a real difference and lead to an earlier global solution of the whole dispute.
Robin, from your experience, both as a professor and as a barrister, what proportion of licensing deals would you say require mediation? And what are your general reactions to the presentation we heard?
Well, I've done quite a few mediations since I retired as a judge, and a few arbitrations. And the process of alternative dispute resolution is actually a valuable way of getting cases settled. In some cases, if you've got one party who says, I'm right, that's the end of it. You can't negotiate. But that's not these cases, or shouldn't be these cases. It's got to be recognized, however, that this is not a panacea. I don't believe you're claiming you can bring peace on earth. You are a valuable aid, and from what I've been hearing of what you're planning, a more proactive aid than, say, the WIPO Mediation and Arbitration Centre, which exists already. You've got a rival, and I think they may have a young snapper at their heels. But in the end, we have to recognize that alternative dispute resolution, in the end, is what happens in the courts when everything else has failed. As von Clausewitz, adopting von Clausewitz, litigation is the continuation of Litigation is the continuation of negotiation by other means. And this is a valuable way of making peace when war has broken up, or is about to. And I wish you the very best of luck. I have to say that over my own experience of IP arbitration is it's rather limited in the world. I'm not talking about SEP, I'm talking about generally. There is some arbitration, but it's a pretty low figure in the world. And one of the most valuable things you said, you're not really a centre for the UPC, you're a centre for the world. And if you can make it run, well, the parties might be, you know, Indians fighting Chinese and coming to you to sort it.
Nicola, you also have a lot of experience in this area. What is your reaction to how the PMAC is unfolding, and what is your experience in how these types of cases play out?
Well, good afternoon, everybody, and sorry not to be with you in person. I'm in our San Francisco office this morning, my time, but I'm very grateful to be able to join you. Look, a huge warm welcome to the PMAC from my perspective and my practice's perspective. At the end of the day, these SEP and FRAND disputes are large, high-value commercial disputes. All that really matters is how much money must be paid. And those are exactly the kind of disputes that are ripe for settlement in mediation, or failing that in arbitration. And indeed, you know, my experience and our experience in the firm is that mediation has worked really well. It has solved the full series of the recent large FRAND disputes that we have been involved in. And I'm sure the PMAC Centre, when it's up and running, will play a vital role in that. I think for mediation to work well, and this is in line with some of the features that we heard about in the presentation, there have to be experienced, skilled mediators available. Those mediators, if they're able to put together structured mediations, that really helps. And by that, what I mean is it's not just a one-day or half-day formal meeting. The structures need to be built for the disclosure of the comparable agreements, for the mediator to have assistance in digesting those comparable agreements and understanding what the real rates are. There may need to be a number of staged mediation sessions. And frankly, the mediator, you know, the great thing is there are mediators that have endless energy for doing these things. High energy commercial mediators who show patience at the right moments, but show energy in bashing heads together is really the recipe for success. In terms of arbitration, what works really well is, well, it tends to work really well once there is an agreement to arbitrate. That's the toughie patch, is getting the agreement to arbitrate. But once you've got that agreement to arbitrate, you know, safe in the knowledge that there aren't going to be interventions from injunctions in the meantime, that is, that there is a standstill on, you know, in the litigation world, so that the arbitration can proceed, and there's a window, you know, a window for that arbitration to move forward. Arbitration is also very, very successful. And, you know, we have seen again, very recently, that a number of the very big FRAND disputes that have occupied the court for several years have ultimately got sent off to arbitration to either resolve the existing agreement, or the need for the existing agreement, or the follow-on agreement. I think what works really particularly well in arbitration is when the tribunal has the discretion to set the full terms, not just the monetary terms, but the full terms for the FRAND license. I mean, obviously there will be parts of those terms that the parties will agree on, but to the extent that there are parts that remain unresolved, which can be quite sticky, like the scope of the patent piece, giving the tribunal, the arbitral tribunal, the discretion in the arbitration agreement to resolve the full set of terms really does make for a very successful route forward.
So, Alice, we've just heard a whole lot of feedback there on the PMAC. I think largely welcoming feedback. Also feedback that it's the new kid on the block, young upstart, if you will. What is your reaction to some of the feedback we've just heard?
Well, I'm very happy with this feedback because I heard a lot of support, and PMAC will need it, in fact, in particular from those who have experience with mediating and arbitrating similar disputes. So, for example, what we plan once we have a list of accredited neutrals, we plan to design a specific training program for them, advanced training. And this, of course, will include the specifics of arbitrating or mediating the SEP or FRAND determination issues. So again, here PMAC would need the help of those who can help. And I know that among experienced mediators and arbitrators in this field are many who are also trainers. And this will be for benefit of the future services of the PMAC. And I agree, of course, all these alternatives to litigation are not panacea. It's not a medicine which would cure all the illnesses of the, let's say, justice system in general. But on the other side, if you have a system where the parties can choose, you know, it's like going to the restaurant. When you enter, you ask for the menu, right? And then you see on the menu a lot of items, and then you need a waiter to help you to make your decision. And I hope that mediation will be almost a standard appetizer on this menu. It's just we are widening the opportunities for future litigants, disputants, and that's it. That's actually why PMAC was established. So it's a kind of multi-door courthouse model, together with the UPC, of course.
It's a popular metaphor, the menu metaphor for this. Cordula, I want to go to you because, as I mentioned, you helped design these rules, and we've heard from some of the other panelists that there can be some real hesitancy to engage in this type of voluntary mediation and arbitration. How were the rules specifically designed in order to encourage people to encourage companies to go in that route rather than litigation?
I mean, in principle, when you go to arbitration wherever, it's mostly upon the parties anyway. The parties are usually free to set their specific rules. So it's not like you can only get a certain type of circumstances under now the PMAC. But I think the advantage there is that through the specific rules, there's like the menu you mentioned. There are already ideas. There are the mediators or arbitrators who are prepared for that, who shall have experience with that and know how to deal with the parties. And I think that's the biggest point there that makes it attractive, because this is then a PMAC, an arbitration center that is prepared for these type of disputes, having the mindset for these type of disputes. Specifically confidentiality rules, which are usually take up a big part of the procedural dispute in these type of litigations, but also potentially staging things or cutting out various aspects. We also earlier heard about the technical discussions, essentiality, and then the actual rate setting, but it might also be other licensing issues. Is there exhaustion or not? What's the scope? What portfolios should be included or not? So there are various questions, and maybe sometimes also litigation can be more streamlined if certain questions say, okay, let's sort that out amicably. And maybe that's then an in route to also settle the whole dispute at the end. So I think that makes it very attractive, and all that, in many cases at least, I would think it will be part or upon the initiative of actual court litigation. So we have maybe the incentive by the judges saying maybe this would be a good idea, and thereby giving a little bit of a push to the parties who of course need to agree to arbitration, and that can maybe make a difference, because in the SEP world everything is being settled. There is no SEP dispute that is not eventually being settled. The question is just when and how. And maybe this is a way to provide another solution and advance this process.
Richard, I wanted to go back to some of the case law experiences that you mentioned specifically with Nokia. Thinking of the LSG case and the Samsung mediation. Which procedural choices during that process proved the most decisive for getting a settlement? And what kind of lessons can be drawn from that for when we're institutionalizing this process at the PMAC?
Sure. So these two, LG and Samsung, were arbitrations. And the way we set them up procedurally, a couple of things. First of all, we put the license in place at the outset, so there was already a license. So we didn't have any arguments about parallel implementation patent cases or any of the interim license stuff like that. The license took effect, and the only question that the tribunal had to determine was how much. And that kept it simpler. The other thing we did was we provided for an early exchange of license agreements, and it wasn't, rather than have some sort of argument about scope and all of that sort of thing, what we did was made for a fairly wide disclosure. So both Nokia and Samsung put their license agreements into the pot, and people were able to see them. Now, one of the problems with arbitration is that all of our license agreements have these terms in them that say they're confidential, you mustn't share them with anybody else unless you're ordered to by court order. Now, the way we get around that is we get the tribunal to order a disclosure, and we put in place an external eyes-only regime so the solicitors on each side can see them and the experts can see them, but the other side cannot. But this is still a bit of a fig leaf. We're all politely ignoring the fact that this isn't a court order, and perhaps in theory we're all in breach of our confidentiality clauses when we go into an arbitration. Now, one of the great things about the PMAC is that you could get the UPC to order the disclosure, and then you've got them for the arbitration, and then we've solved that problem that we've all been quietly ignoring for the last 15 years. Once you've got those disclosed and both sides are able to inspect them, then you can move forward relatively quickly. And in both cases, we put forward a very tight time limit on it. Of the tribunal had to give an award within a certain date. And that's one of the best ways of containing the costs, because lawyers bill by the hour and they will keep billing until you get to the end of the action. And if you've put a limited time limit on the whole thing, oh, sorry. I've forgotten I'm back in private practice now. I shouldn't admit this. But if you put a firm cap on the date by which this is all going to be over, then that acts as a de facto cap on what the costs are. The final point I'd make is that Nicola was mentioning that these disputes are high value, and they are high value, but that's a self-selecting thing that we're seeing at the moment. The only things that get litigated are the high-value ones because litigation is expensive. The only things that get arbitrated are high-value because arbitration is expensive. But there are a whole load of low-value disputes. There are an awful lot of SMEs that are implementing some form of communication technology, and it would be good if there was a dispute resolution mechanism that could fairly address those guys. So if you could have a really cut-down procedure for a low-value case, I think that would attract much more.
Yeah, and maybe that is provided. There is also this kind of expedited proceeding, or where usually there should be a decision within 6 months. It can be just written procedure, so very streamlined. I think it's foreseen at the moment below $1 million dispute value, but parties can agree to that. So that might be actually a solution for the not high stakes cases.
And that isn't just for SMEs, right? That's for any such
company. Anybody who agrees to that, yes.
It's a very big difference when you put the judge under a time limit, as well as the parties. Judges aren't used to being under time limits. And what Richard said is absolutely true. Work expands to fill the time available to do it. Give it lots of time, lots of work. Work contracts to fill the time available to do it as well. And it's a vital rule, I think, and you may want to be thinking about that, kind of expedited mediation or arbitration, so that, put something in the rules about that, so that people can say, well, this deal's going to be done one way or the other. Sometimes it's better to get a slightly wrong answer early than a perfect answer in 5 years' time.
Peter, let's go to you next. You've indicated that there's somewhat of an information gap when it comes to cases, particularly with the German and UPC caseload figures that might be underreported. What kind of reforms to filing, docketing, public reporting could be made to try to fill that information gap?
I'm not sure if I understood correctly what you mean by information gap. Do you mean the general figures concerning how many cases are pending in the national courts and at the UPC at the moment, or?
Caseload figures.
Excuse me?
The caseload figures?
Yes. I think the caseload figures are quite transparent at the UPC. And also the national courts report them every year. So I don't see that there's an information gap, to be honest.
We get, all right, let's open another question for you. So you're working on the PMAC Presidium. Which single upcoming feature do you expect is most going to influence whether parties choose this over national courts, which direction they go in?
Yeah, I believe that, or I personally am already a bit myself surprised that the parties turned pretty much already to the UPC to engage in the proceedings and before the UPC rather than before the national court. So even in the national courts in Germany, which already always had quite considerable numbers of patent litigations pending, we can already see that there's a stark decline in numbers. That sometimes they apparently are being used as an alternative to UPC because you never want to put all your eggs in one basket. But already I think there is, especially in the context of SEP, quite a trend towards the UPC. Maybe not only because you can cover a vast a number of territories, of course, but maybe because the users realize, oh, this is a new system, and maybe it's easier to get through with my arguments and with also having a fertile ground for fresh thoughts concerning the way such proceedings are dealt with regard to the process, to the procedure that we apply, that they rather want to test that new playing ground or battlefield, whichever way you want to look at it. And therefore, my gut's feeling is a bit that that at least the large-scale dispute, may they be technically very complex and concern a lot of member states where you usually had all that parallel litigation in the various national courts and SEP proceedings. If I had to predict, I would tend to believe that the vast majority of cases will be handled by the UPC in the near future, as we see that clear trend already.
Nicola, a question for you on what people should take into account when they're choosing mediators or arbitrators. Based on your experiences with these SEP disputes globally, What criteria do you think is most important when selecting a mediator or arbitrator that ensures both that you're getting technical expertise but also commercial credibility?
So I think it's two different skill sets actually for what you're looking for in a mediator and what you're looking for in an arbitrator. In looking for a mediator, essentially, and indeed as the presentation made clear, you're looking for a very experienced, neutral individual who, you know, is very good at facilitating negotiations between the two parties. You know, the more experience they have, the better. On the neutrality point, I think it is very important that, you know, for example, if there's a Chinese entity on one side, that, you know, the mediator is not Chinese. If there's a Korean entity, that the mediator is not Korean. There's got to be neutrality from that perspective. But otherwise, you're looking for a mediator who can bring all of their training and their skills to hold these negotiations together. This is not a case of like tea and sympathy type mediation. You know, sometimes it's got to be high energy, keeping the negotiators at the table, bashing heads together, holding them together when they have bust-ups and when they want to stomp out of the room and go home. You know, sophisticated mediators have very, very sophisticated toolkits for keeping things going, for finding a way of bridging things, finding a way of opening up alternative communication channels, and yeah, you know, being very commercial, as a number of people have said already, about getting this commercial dispute resolved. I think when it comes to arbitrators, as a number of people said, you're looking for very high quality quasi-judges. You know, the arbitrators are basically judges who are determining the dispute in a binding, final way. So they've got to have all of those skill sets of good judges. They've got to be commercial. They've got to be hardworking. They've also got to be good at case management. You know, we've heard a lot about getting early disclosure of the comparable agreements and getting those unpacked. You know, their ability to case manage that and keep it moving along in a fair way is going to be very, very important.
Thanks. So let's take some questions that have come in from the audience on Slido. This first question is very much related to what Nicola was just saying. It is from Dr. T. Lafargue-Hack. Sorry if I'm mispronouncing that. So Alice, I think this would be a question for you. So the question is, are the selection criteria for mediators and or arbitrators already published, and if so, where?
No, not yet, but they are under consideration, under expert consideration at the administrative committee by the observers. So EPLO, EPLIT, API, Business Europe, European Commission. We will receive the first, let's say, set of feedback on this criteria. As I already mentioned, we want to keep them flexible, these criteria, in terms of providing parties with all kind of selection of neutrals depending on the circumstances of the case. And it's important to note, not just accredited neutrals could be engaged at the PMAC. The parties always can select someone who is not on the list under, of course, approval of the center, and the center will always look whether these basic requirements are met. So we plan to launch the invitation based on adoption of this criteria. We will publicly launch the invitation for all interested individuals to apply. This we will do hopefully over summer and early autumn. And then during the autumn time, the expert committee together with me will finalize the selection process and publish the list. This list must be published according to the UPC agreement. But as I said, we provide full flexibility. You know, the parties are in charge of everything, about the selection of the process, about the selection of the neutrals. So they are the masters of these proceedings.
Next question I think I'll put to Cordula. This is a question from Alex Prenter. How will the PMAC promote transparency in the market if the outcomes of an arbitration are confidential?
That is indeed, in principle, I would say one of the biggest downside of arbitration, that you do not publish arbitration award classically. We've seen that under the UPC, it is possible that the actual arbitration award is then being put like into a decision by the UPC, also to provide the corresponding enforceability. So it will have to be seen how much then will become public there. But sometimes it's also this confidentiality which drives the parties towards the settlement. So it's kind of because there is this, we can talk behind closed doors, that actually parties do get together. And if you take that away, sometimes solutions might be more difficult. And I mean, if I just may add, if you settle out of court, that's also not being published somewhere on the website. The fact that you settled, yes, but the terms of the settlement are also not being published. So it's, yeah.
So yes, I was thinking about this as well. What we all want to know, of course, is what the numbers are, because that's the salacious and exciting gossip, and we really want to see that, oh, so-and-so only got 5 million out of that, and that we're excited about it for about 2 minutes. But that's not what we ever cite about any case law later on. What we actually cite, and what the learning points that come out of the case law, is the methodologies that were applied. How was it done? Comparable licenses, what sort of top-down was used? How was the top-down used? What sort of valuation metrics were being used? That's the stuff that we actually come out and remember, and we cite in future cases, and the useful learning point. The numbers are specific to those particular parties in that particular situation on that particular date, and are of no further real use. So if there was something that could come out which showed methodologies that were being approached, or learning points that came out of the arbitration that would be useful for future people, that would be great. But I don't think we need to publish numbers.
May I make a comment online to that?
And there's particular pressure in international arbitration. Say, and some awards have been published in international arbitration. As regards the publication of these awards, I was thinking exactly the same thing as Richard. You could publish redacted versions of the decision. In other words, none of the numbers are there, but how it was done would be useful. And maybe that's something that PMAC might like to consider, about organising a system where the parties are encouraged to allow something to come out other than the fact that one side says they were very happy with the result.
Yes, and the current version of working document on draft arbitration rules, in fact, this is an option that the tribunal may publish the award or part of award. But of course, there is also a rule that we must respect the autonomy of the parties. In the current wording, it is said that unless in 60 days any party opposes to such publishing, then it can go public, such part of award. Let's see. I expect a lot of different views on this sensitive issue, in fact, during the public consultation process. And this is exactly the purpose why we want to get this feedback and to see what would be the best solution here.
So I'll take one last audience question before we wrap up the panel. This question, Alice, I'm going to put it to you. It's about the EU regulatory implications here, considering the withdrawn SEP regulation. The question is from Inbar Price from MLEX. Does the PMAC bring into question the necessity of an SEP regulation, which might be scrapped by the Commission? Would a new potential approach from the Commission need to consider the PMAC?
I hope yes. I hope yes. We are working hard in this direction. But I think that we must come to the point where we could show the results, not just the plan. I mean, the plan is great. So we need to show that we deserve the confidence, trust to what we are doing, to what we are offering. And that means that we need cases. So I kindly ask all lawyers to consider maybe to test us when we open the door. And let's see. But definitely, I think that the Commission should take this into account quite seriously. Yeah.
And you need some cases first.
Yeah, I can only echo that. I mean, there's a lot of things are ongoing now. With the UPC just up and running, and just the very first decisions having come out there, and now the PMAC coming out. So I think the minimum that should be done is see how these things develop, and whether then, after a couple of years, reassessing the situation, whether there is a need for any regulatory intervention and to what extent, in order not to harm an overall working system. As we heard in the first panel, that a lot of things are working well. The market as such in standards are working well, so that we don't throw out the baby with the bath, and see what is the situation, assess it, and then kind of in a targeted way address those points which are still need to be addressed.
Well, some super interesting insights from all of you. I think it's always really exciting to see an institution in its infancy here, and there's clearly no shortage of ideas and hopes about where it's going. So thank you all for your feedback. How about a round of applause for our panelists? So now I'd ask you all to take your seats. We're going to do a transition and a little bit change of furniture here, but everyone please stay in your seats. There's no break. So we're going to go straight to panel 4, which is on European competitiveness in a changing global landscape. The role of patents and standards in safeguarding technological sovereignty. And if you do need to leave, please do so very, very quickly. You can sit in any order you like. Let's see, we're going to try our very best to have all 6 seats on stage here. So in this next panel, we're going to be talking about, as I mentioned before, a big preoccupation in Brussels right now, where I am, which is about competitiveness. We've had the Draghi report come out, which is advising the Commission on how to increase the competitiveness of the European Union. And one area where we can really do that is with standards. So in this panel, we're going to be talking about how we can use Europe's edge in standards to also give it a competitive edge in business. All right, I think we've got everybody here on the stage now. So this is very much going to follow on from the previous discussion about the PMAC, and we're going to discuss how Europe can leverage some of these things we've been talking about. How Europe can leverage its strength in SEPs, research, regulatory leadership to maintain a competitive edge. We'll talk about the impact of AI-driven transformation on industries and how it's impacting IP issues. As we've been hearing today, technical standards can help drive innovation and growth by ensuring that interoperable and secure technologies are widely adopted by businesses and consumers, both in Europe and also globally more broadly. And patents, as we know, play a really key role in this process by incentivizing research and development and making innovative technologies available for standardization at an early stage. So, how can people involved in IP, standards, and patents take these new realities into account while ensuring a balanced ecosystem for all players? Let's turn to our distinguished panel of experts for their ideas on that subject. We'll introduce them to you now. So here with us today, we have everyone in person for this one, nobody online. We have Gabrielle Mosler, who is Vice President for Patent Creation Management at Ericsson, so representing an SEP holder. We have an equal number, by the way, of SEP holders and SEP implementers on this panel. Gabrielle was also formerly a patent attorney and is president of the German Licensing Executive Society. Then we have Alexander Hertel, who is cluster for lead patents at Deutsche Telekom, representing an SEP implementer, former patent litigation attorney himself. We have Steve Farahi, Head of Litigation Licenses and Brand Protection at Volkswagen, also representing an SEP implementer, and also a former Head of Vehicle Patents at Audi. Then we have Lise Brillouet, who is Executive Vice President for Research and Chief Intellectual Property Officer at Orange. Then we have Sophie Pasquier, who is Principal Licensing Counsel at Philips, also representing SEP holders. And finally, we have Gabrielle Bovin, who is Head of Intellectual Property, responsible for patent filing and licensing activities at the French broadband telephony company Sagemcom, also representing an SEP implementer. Thank you all so much for joining us today. Alexander, I'd like to start with a question for you. So as somebody coming from the litigation perspective, what difference do you think transparency and standards can make to competitiveness?
Well, first of all, thank you for having me here, and maybe just a very minor correction to your introduction. While we are mostly seen as an SAP implementer, we are also an SAP holder, so we have quite a view from both sides of the table a little bit. Transparency, competitiveness. I think if you look at competitiveness from two angles, there is the competitiveness to enter a market very rapidly. So if you develop a new product, you need information how to enter that market. What licenses do you need? If you're on the other side of the table, if you're on the holder's side, you want to have competitiveness in strengthening your IP system and like strengthening your patents and having a safeguard for the value of that IP. So like increase your or like maintain your return on investment so that you can refinance your R&D costs, which is essential in this world. So the interconnection between standards and innovation is really that you need to have both these sides. You need to have early access to a technology by enabling companies to have that transparency knowledge. I mean, knowledge, what does it do? It leads to an increased decision making. If you have knowledge about what you're doing, what are the costs, for example, what are the patents that you need to license, then you can do a very rapid decision on what you need as a licensee. So I think this is really the core concept of increasing transparency, that everyone is able to make a rapid and educated decision on what they are doing. Because sometimes you have in the current system, there is a little bit of, let's say, a one side or an asymmetry of information flows. So I give kudos to the EPO for the study that they've conducted, because they already provided a little bit of data set, especially in regard to like probabilities of essentiality, etc. So there's already one piece of mosaic coming into play here. But what kind of transparency is needed when it comes to licensing? That is one side, but you also need a transparency on the cost prediction. And I think that's something that, especially for all those emerging markets, so not in the classical markets that we are already well established, people know the prices and who the players are, but when we're looking at IoT, quantum computing, whatever, there are new markets generated every day, and I think for those markets especially, an increased transparency and knowledge gain is really important.
Gabrielle, let's turn to you next. So as an SEP holder, how do you think patents and standards can help with Europe's competitiveness?
Let me also add a little bit to what Alexander said, because we are also an holder, but we also implementer because we have products. So at the end of the day, we are not representing just one side. But I mean, understanding that it's quite late in the day already, let me start a little bit with one fun fact. And it's not a hoax, I tried to find out. So there are more phones available in the market on the world than there are toothbrushes. So, and you can check this, and I mean, I tried that it's not a hoax, but what does it mean? I mean, you asked me about competitiveness and this stuff, so you can look it up, and remember it, and actually it was not coming from me, I heard it from one of our R&D people, and I checked it, and I checked whether it's a hoax. It's not, so let's assume it's right. Competitiveness, let's look a little bit at, I mean, who is providing phones nowadays? I mean, there's very little European companies in that. But if you look in, I mean, the whole or a lot of the infrastructure or a lot of the inventions are done coming from the infrastructure side. And this is where we have competitiveness here in Europe by having companies that are able to come up with good ideas. I mean, there's several ones in the US, there's also several ones in China and around in Korea. But I think it is important, and here I come to the point now, that we have a fair return on the investment we are doing via licensing in order to reinvest it again. And this is the R&D which we are doing around the world, or which companies like us do around the world. And the whole standard system is only possible to be alive if we have an understanding that there has to be a fair return, and that doesn't, and with this the whole competitiveness in Europe is super important. And this is why I think I'm talking here about super important for us to stay competitive and also be in a system here in Europe where, including the patents, where we can really facilitate good licensing negotiations. And then last but not least on these points with the licensing, I think we need to get into a system where it's not about to save money. And I personally, and that's my very personal view, I think if you look at the license fees, and some are public, this is not a lot of money in my view. I know people have different views on it, but if you're honest about this, how much investment is done in this one, we cannot afford to let this drop down. And I think we all together have to work on it. In my humble view, I think the license fees should be much higher, but nobody asked me.
Well, Steve, I thought you might have thoughts on that. Let's go to you next then. You know, I think it's safe to say that Europe does have strengths in research and in SEPs, but sometimes those strengths aren't leveraged. So how do you think Europe could do a better job leveraging those strengths?
Thank you very much. Also, I want to continue the train of saying that we also have SEPs, so some. Thank you very much. I'm very honored to be here with the distinguished conference and the panels. I also want to laud the EPO Observatory for this activity. The study is really interesting. It is a start for additional data and a toolkit for the use of stakeholders. How exactly we can use it, I think, has to be seen. I'm with Rudy Beckers there to be a little bit cautious. And I'm also very happy to see that Aleš is setting up the PMAX so greatly, and it's really a great job he's doing, offering us additional tools for everyone for resolving SEP issues. However, and now I have to respond to the question of Klaus Grabinski whether we need the SEP regulation anymore, with a resounding yes, because this doesn't replace the SEP regulation as it was proposed. I strongly believe that, because we need regulatory intervention. We have been at it for 10 years now in policy debates and discussions, and there is definitely friction and market uncertainty. I think we can establish at least a baseline of there are some problems. And I believe that the proposal, the regulation, has addressed some of the issues and proposed some solutions for that. I know this is not a popular position here in this room, but still I'm happy to provide that and to wake up everyone. And I want to perhaps a little bit also caution on the interpretation and the study of the EPO Observatory on interpreting out of the fact that most licenses are concluded without litigation. That does not mean that there is no problem, you know. I can also say from an automotive perspective, when you see that some companies get a bloody nose in the first instance, you are probably not so keen to enter into litigation and even negotiating or let's say discuss anymore, because you know what the end result will be. So I really I am hopeful that the regulation will be revived, because I think it's a mistake that the European Commission withdrew it. And I'm really urging everyone that it's needed to negotiate. This is something that is, I think, missing, and everyone should have an interest in that. And perhaps just quickly, we need more efficiency and accountability also, because as you all know, some license rates are set up without any accountability. Nobody knows what, as a licensee, you are buying. I think that is a really major problem for even patent holders as well. That has to be addressed and would be addressed by the SEP regulation should it be revived. And it is also, this accountability is also foreseen also in the ECJ Huawei ZTE decision. So you should show where the license rate is coming from and the calculation. So I strongly believe that regulation is needed in any shape or form. I believe that the European Commission should reconsider, and we will have to see. And I'm looking forward to the discussion. I hope everyone is woken up now. So, yeah.
Well, Liz, on that topic of the regulation, the withdrawn regulation now, do you think we need more regulation to improve Europe's IP practices?
So we are fully woke up, be sure, be secure. Thank you very much for having me. And perhaps before diving into this polemic subject, I would like to remind that we are always innovating to deliver good services for our customers, not to do patents and to file patents. It is really the first objective for those big companies in telecommunications. It's really to bring competitiveness at the European level. It is about innovation at large. It is not about making some additional euros with patents. And so in that way, to bridge industries around this topic, I think the way we have to consider that might be extremely open, and I would like to come back to the why. Why are we here today? We are here to celebrate, so I'm not sure there is some champagne at the end of this day on the menu, but we're really here to celebrate a very key initiative from the European Patent Office by bringing an additional tool, an additional capital to really bridge industries, to make things more explainable, to bring transparency. And it was part of the issues to fix between industries and companies, making things transparent, making things balanced, making things explainable and predictable. And probably many companies in that room consider that there is no market failure, and we have years of practices behind us demonstrating that we always have been extremely keen to give access to all to our discoveries and inventions. So I'm pretty sure that by negotiating, discussing, bridging companies, we might be able to really fulfill the gap we have today between companies. So, of course, there is always room for improvement, and probably depending who you are in the value chain, the burden, administrative burden is not the same, considering having more governance, more reporting. But I'm pretty confident that we're on the right way. And finally, I will leave the floor to Sophie, but I think it's very important also to consider that it's not a European issue. It's a worldwide issue. Our game landscape is not European anymore. And that's very important, because even if we want to be absolutely exemplary in the way we do, in the way we practice, we have to comply with worldwide rules. And our aim, as for the automotive industry, telecommunication industry, like Gabrielle said, we have to remain competitive. We have to keep ahead of the race. We have to maintain big industrial champions at the European level, and that's capital. It's vital.
Sophie, Philips is a company that is both involved in implementing technologies in its products, but also yeah, not to say it's only you. So but you're also innovating and developing standards. So
yes.
What's your view on the patent licensing practice as it exists now? And in terms of patent licensing agreements, do you find that they usually result from negotiations or litigation decisions?
Yes, thank you very much for your question, David. And also thank very much the EPO, both for inviting me today and giving a voice to Philips, but also for this great initiative. This panel was lucky enough to have access to the report a little bit ahead of you, so we could read it. We had 2 days before the conference to to access to it, so I will make use of it. And I want to say that the first comment I have on the first part of the presentation today is that we see, I think we can all understand that the EPO, the European Patent Office, is best situated as an organization in Europe to make any discussion related to technical aspect of patents, such as, for example, hinting as, is there any essentiality trend on this patent? Because you have access to data and all what is necessary for that. I think we are all convinced in this room that this is where, if there is technical issues, if there is technical discussion about patents, it should go to the expert who have established their practice for decades. So thank you for that. The second aspect of this report, here I turn to justice, making a very important step, I would say, into transparency, because we hear a lot about litigation. Litigated cases are the buzzing in the press. Richard was referring to it. We love to speak about it. We are curious about who will be winning, how much money, what is the tactic used. We speak a lot about it. But how many cases over the last 10 years in Europe? Justice was clear about it. 101 case filed. And when you have access to the report and you look at the annexes, you can see that behind those 101 cases, meaning 10 cases a year, that have been filed, there are actually 63 negotiations that did not result in a patent license agreement without going to court. 63 over 10 years, 6 negotiations per year. And if you look at the parties, the defendant, it's sometimes quite often the same party. And on top of that, you look in more detail of those different litigation, you might find out that some of the litigants come from a patent pool. So in fact, with one pool transaction, we could have avoided many of those litigations. So it's even less transactions that are derailing. So you would say, okay, fine, but how many license agreements are signed? Because it's good to say that it's only 63 cases, but maybe there are only 100 cases signed per year. But in fact, so for this, Philips is is part of many patent pools, and we have, we are involved in many technologies from audio, video, cellular, wireless charging. So I have people very knowledgeable in our company who gave me some data, and I want to report that to you. If we just focus on audio-video pools, which is standards which are very well managed, for which there is licensing agreements since long time without any waves. There is AVC, AAC, HDMI, HEVC, MPEG, M4 and 2, VP9, MP3, DVB, all that is patent pools. This results in 7,000 licensees. Most of them have renewed their license. We are talking about 23,000 patent license agreements just for audio-video. On top of that, you add those new pools in IoT for Avanci, where they have more than 100 car makers now with 100 patent license agreement, maybe some renewal, 2 different platforms. On top of that, you add the patent pools dealing with Wi-Fi. And you should add also all the activity that is occurring, especially in cellular, as a bilateral negotiation, where companies like Qualcomm, Nokia, Philips, Ericsson, Huawei, LG, and so on, are signing patent license agreement every year, where you could imagine there are hundreds of patent license agreements to add to this decounting. So now let's look at the ratio. 63 litigation, or 63 negotiation that leads to litigation, compared to 25,000 more patent license agreements signed. What are we trying to fix here? I really ask the question, is it something that is not working? I mean, if we compare also the number of litigation related to SEP compared to non-SEP patent, in fact, it's a very small ratio. So yes, we could say, yeah, but if you compare to the total number of SEP, it's quite high ratio. But SEPs are designed to lead to license negotiation where there will be a payment. Not all the other is patent, non-essential patent. They are here to protect, to keep your exclusivity, and you send a warning letter, you're using my patent, design around, or I will sue you and look for injunction. Patent essential to standard, there is a promise that is done by the inventor at the beginning that they will propose their patent in license. So necessarily there will be friction and discussion. It is the essence of it. So 63 litigation on that basis is really not much. And I know the automotive has been a bit under pressure over the last decades, but I believe that there will be a learning curve like you had. If you look back 15 years ago, there were a lot of friction as well in the mobile phone business. But both companies have to learn from each other, and I'm doing this job since 20 years. You learn from both sides. People have to convince management that yes, there is a cost associated with innovation that was not planned, yes, and this is new, this is a shock, but that doesn't it is not necessary to have a regulation to solve that.
Round of applause for that one. We'll come back to this regulatory issue, I think.
I think it is not a shock anymore. Huh?
Yes. Gabriel, let's go to you next. So from your perspective as an SEP implementer, what role do you see ADR mechanisms playing in resolving licensing disputes?
Yeah, thank you. So first, as everyone is doing the same kind of clarification, I have two. So we take part of standardization. We've got some SEPs, but our business is in bringing products to the market. So back to your question. Let's say litigation is a failure, I would say, a symptom of a failure. We are talking about SEPs, so obviously there will be a resolution in a way or another. We are not talking about ordinary patents. There will always be a way to solve the issue. Usually it's a license. It might take several forms. Discussion might be long, but indeed litigation is just symptom of something which gone wrong. And if we take that principle, I think that ADR mechanisms, especially mediations, are quite positive and important, because when we look at continental Europe, in which courts up to now are only addressing, I would say, infringement or validity or patent, while actually from the business point of view, both from implementers and from licensors, what we care is not those 2 or 3 patents which are in litigation, is how much will the license be paid. It's just a matter of how much. And ADR mechanisms allows to still address this issue. And in case the parties fail to reach an agreement during negotiation, even if they tried, bringing a neutral third party, which still addresses at least the core of the business issue, is something which is quite valuable. That being said, ADR mechanisms, as we are talking about money, we are not, well, it would be pointless to use ADR mechanisms instead to decide just if a patent is infringed or not. What we care is how much are we going to pay. So it needs some data. And within the data, from an implementer point of view, the first data which is useful and which will also be useful to the mediator or to the arbitrator if we want to decide about how much is the total stack for a given standard. So for that, aggregate royalty determination is a key point. At least for us, for business, it just means we need to predict and to put aside a set of money when we bring a product to the market, which is a provision for licenses. Because usually, all of the licenses or all of the demands are not known upfront. So we took some provision, but it needs to be accurate. Otherwise, we cannot drive our business correctly. And it's the same kind of starting point which will be used by mediator or arbitrator, because at the end, it's very likely that we will need to reach a decision on the price. So getting the first data, which is undisputed, we might need some tweaks here and there, but an independent third-party data which is available for everyone, which is the same for everyone, would be crucial. And it's one of the points of the SEP regulation to bring this kind of data to the public knowledge, which could be used by both licensors and both, I would say, product manufacturers. And it's likely that we will also need some view on essentiality. We might not need to know the essentiality of every patent. I mean, when we're talking about huge portfolios, that would be a strange idea. But we need to have, I would say, a grossly accurate guess, because essentiality rates are sometimes quite different between licensors for various reasons. I'm not saying that it's right or wrong, but it's a reality. And it would be quite unfair to just split the total royalty stack by number of patents, because not everyone has the same essentiality rate. So those kind of information will be used or will be needed so that SEP holders get a fair reward, on us, product manufacturers, get at least a visibility on what we need to set aside for the market. So I think that ADR mechanisms are nice. They are, I would say, nearly a necessity in case of failure during negotiation, especially in continental Europe, because that's the way to know how much. But I would say they are complementary, or they are a supplemental tool which can fit within the idea of the SEP regulation. I mean, the SEP regulation by itself is not a goal, it's a tool. ADR mechanisms are also tools, and the end goal is just to know how much. So for licensor, how much will they get? And for me, how much do I need to provision for a given device?
Steve, you wanted to come in on that, I think, on the regulatory.
Can I also say something?
Yes.
I mean, I reacted, Gabriel, we share the first name, so let me say I'm not sharing what you said on SEP special patents. I mean, if you look in the patent law, it says patents. The difference on SEPs is the way you license, that you have this contract there. And I think I'm always reacting on this when people say this is something special. It's the patent as such is the patent, and I think we have to be very clear here. And also, how are they created? And I think it was mentioned by you before. These ideas are coming up, and we are always talking about the best technical solutions, and then a patent is filed, and then later on it might turn out to be related to a standard, and then comes special, or it's declared, and comes to special ways of licensing it. But I'm always getting a little bit aggressive, despite our first name, that I feel that this is not, a patent is a patent, and nowhere in the law it is stated differently. Where is it?
Back to differ, because it's really hugely important. I know that it's a lot of discussion about this. We are coming from standardization. Standardization under competition law and antitrust law is allowed to collude together to develop the best technology. And there is a FRAND encumbrance to the patent. The patent is not a patent per se, like a free one, as you said, non-SEP. It's an SEP, it has an encumbrance, so it's something we have to take into account. It's not reduced in value, it's the opposite. But still, there is something we have to really take into account. It's important to note, and this is something we discuss, I think. And perhaps just quickly to go back to Sophie, because she had a really forceful position here, which I fully respect. I still think, it's not an imagination that there is friction and market uncertainty in SEP licensing. I can just tell you that this is the case for us. And it is also the case that a lot of stakeholders, member states, the council and also the parliament, problem, have articulated this. And the Commission proposed the SEP regulation also because of this. So it's not really an imagination. I fully understand your argument with the numbers and saying there are just 60 license agreements or litigation cases. But as mentioned in the beginning, if you have the experience of how this can go, you are quite reluctant to enter into litigation, and you have seen cases where licensees have signed a license agreement because of the threat of injunction, because they have to accept supra-FRAND rates. And I'm not talking about specific companies. There are a lot of SEP holders who are behaving perfectly, and it's fine. But I'm thinking also to the benefit of SEP holders, a little bit of a framework where we can really gain efficiency. it's not efficient at the moment, unfortunately, and it's not really accountable. I think we can really improve there for the benefit of everyone, because this will only repeat itself in other technologies. I mean, we have IoT devices, everywhere. And this is a problem. It was in the smartphone area, was a problem. It's now in Industry 4.0 and IoT. I think everyone would be helped if we can really streamline this a little bit and have a better framework.
So,
Sophie,
allow
me to answer. I think, in fact, we agree. I think we agree. We agree that in the smartphone industry in the past, there were friction and that they have been resolved today. We agree that today, or let's say in the last 5-6 years for automotive industry, there have been friction and it's been difficult. I don't say the opposite, and you had spoken of it very much, where I think it's very important to make the difference between speaking a lot of problems and what are the actual transparent data behind it. That's why I really want to have the set of data. Data are key here. How many actual litigation were happening? Now, I agree with you, there are friction because it's a new information that comes. In the past, automotive industry was not using cellular. You were having your own issues and so on. And suddenly, cars became connected. People even love by saying it's a smartphone on 4 wheels with a nice battery engine. But, so, yes, suddenly you became a connectivity industry, Yeah. So, I can imagine that your management did not take it very easy to see that there are innovators in this field, there are standards, and they have actually made a promise to give a license, or they would actively go out and license those patents. It's a very different paradigm from the past one that you were with. And that necessarily leads to some friction because there is money involved. But I am sure that with time, industry player will find solution. We don't need regulation because it's case-by-case solution. You are talking of other technology. I mentioned audio, video. Did you know that AAC had more than 8,000 licensees? Have you heard of that? And this is a technology that is in your phone since 15 years. And this is working well. We don't need to have regulation to solve that because we are big boys. We know how to do business. We will learn from each other. I don't say one knows the truth and the other doesn't. And we will find solutions.
Before you come in,
just quickly, we are big boys, that's fine, and we have learned a lot. That's also, we have also experts on our side. You can engage law firms. The problem is, we don't have any leverage. As a licensee, you have nothing to offer and nothing on the table. It's a one-sided negotiation, if at all. It's a one-sided licensing terms and conditions. Take it or leave it, and that's a little bit the problem, I think. I think that's the reason why regulation, at least a little bit of regulatory intervention is needed, because it's not working overall. There is friction. It's not friction that we have to pay something. We are happy to pay. There is friction in negotiations.
Okay. Today I made Steve say that he's happy to pay. No, but you have leverage because you can always go to court to say this company is not offering FRAND rate.
We go to Munich, willingness, gone.
You can choose your court. If you go, you choose your court. Yes.
Okay. It's like playing the Olympics again, right? No? So not sure we came for playing a show. I think that we have to step back a little bit from this situation and really consider what is the global objective at large, really. I think that it's very important to find a short-term solution. And even if we ask for more regulation, it will take time. So we need to adjust each other before. I think it's really required. And also probably to move the needle. We need to move the needle, either on SEP holder side and SEP implementer side. And in the regulation, we worked a lot on it. We've seen unbalance in this regulation project, right? So whatever the route we'll have to play, even if we'll get a regulation one day, and we had very fruitful discussions and collaborations between car manufacturers and Orange, for example, in France before the regulation was withdrawn. Very encouraging, very promising. I think we are good how would you say? Good boys, big boys, adults. And so it's very promising. And even if we agree, whatever the context will be, you will have to deal with patent holders from China, from the US, and they will not comply with European regulation. So it's important really to consider, once again, the global overview of our IP practices. It's much more than our hexagonal or European landscape, really.
Alex. Yes, maybe to add some more comments on the whole discussion here. I think Sophie already brought up the example of just 63 litigations. That's very little in comparison to all the license agreements. But I think when you look at the history of all these patent pools that you've described, in the beginning, there was friction. So in the beginning, no one wanted to pay the rates that were asked for. So it took all the SEP holders or all the stakeholders at that time a lot of effort of initiating litigation. After a while, of course, that smoothed out in a sense. And I think that is the same picture that we see with every emerging technology, every emerging, let's say, product that comes onto the market. So we saw it on the POS systems. So wasn't successful licensing in the beginning, but litigation ensued, so people started following that. So, and the same trend will happen with IoT, it will happen with every major development where certain standards are implemented, smart meters, whatever you say. So this will be happening again and again and again, and we need to do something to enable those companies in the very beginning to get, let's say, that information asymmetry gone, to have some, let's say, neutral authority or let's say like the PMAC or whatever, to set something or to establish a price rate in a sense which is based on the factual sides provided by both sides. So, and I'm very keen on putting this forward because it's important to have that mandatory. I really applaud Alej for putting up all these efforts, and it sounds really great. It sounds really promising. It's just voluntary, and I think there are problems with parties on this in this discussions here that are not behaving very well. So you have outliers on the far left and on the far right side, in a sense. You have them on the implementer side, you have them on the holder side. And I think a system where I can force also an SEP holder into that price discussion, that would be super beneficial, and also for the SEP holder side. I mean, sometimes it's difficult to engage parties into these license negotiations. We all know them, and if I could get them on the table and say, okay, this is the price some independent expert said, you should pay, please pay it. It's much easier for them than to convince their management and say, okay, this seems to be a reasonable approach.
Sophie, you wanted to reply?
Yes, absolutely. Thank you, Alexander, because I also very much agree and recognize my life of every day here. It's true that at the beginning of a program, because some player, again, it's a new information that is coming, they need to convince management, they need certainty, and even sometimes they would need to be litigated to be convinced. Management will say, let's wait and see if they dare to litigate. And they want even to see if the patent will survive. Because that means, yes, there is a real risk, there is a value, and that's how you assess your value. That might be a business model. Some will do it at a different level. They have internal resources, or they will hire to assess the patent. But if you think of the predictability that you're talking about, I wanted to make that remark about the fact that there are patent pools today. I would like, sorry for that, Steve, but to look at the 5G patent pool platform of Avanci. So now we are talking of something where you know exactly how much money will be involved in 5G. There are not many cars today in 5G, so this is ahead of adoption on the market. Predictability is here. So normally, if all what we hear is correct, that when you know the price, when you know the patent are essential, and when you know everybody pays the same, all those three conditions are met, everybody should use to take a 5G license at Avanci. all is done now. And same thing for each and every pool that is created. I'm referring to the Wi-Fi 6 pool of Sysvel, where now, you know, there will start to be a ramp-up of Wi-Fi 6. The thermal node, all the patent that goes into this pool, there is expert who will look at essentiality. So again, all those three conditions are here. So everybody should use. We should even not go and send letters. People are aware, this is public information. They should say, okay, I need a Wi-Fi 6 license, I'm going there. And this is not happening.
Go ahead, please.
Also, just to say that the title of the day is Patents, Standards, and Competitiveness. And we're fighting in between industries. I think it might be really much more constructive to work together. Because today we are talking about wireless or codecs, but I will take the illustration of artificial intelligence. So we've been working on artificial intelligence for 35 years for algorithmy, 20 years for languages, and 13 years for large model language. So probably, and I hope so, on today we'll get some standards for artificial intelligence. So we've just published recently a very good paper, so it will be the only advertising I will do for this session about frugal AI. So it's for scientific and illustration purpose. You can see this on my LinkedIn. And we received a very good response for the American continent. So we're about to be published in a very, very good journal, a scientific journal, probably invited in a very high conference, scientific conference. So from all these years and decades, we put tons of time and resources, and it will come, once upon a time, to standards. So are we going to fight once again about the price or doing some litigation? No. I think that we could leverage from the champions we get in Europe, seeing how to leverage from what we do. Because it's hard for the automotive industry, probably it's hard for SMEs ecosystem in IoT in Europe, but it's hard also for couriers, for example. We are in a very critical situation. We have more than 25 couriers in Europe. This is competitiveness issue. So it's really important to step back, move the needle, and see what we can do by our own. If finally we need more regulation, we'll go for that, of course. But since we are here today, I think there are some key initiatives that could demonstrate that we could agree on some robust data toolbox, and being willing on each side to make a step and to move the needle, because there is always room for improvement, of course. It might be very, very powerful for all of us, much more.
Well, several of you have made the point that you don't collect patents just to make money off of patents. The whole point is about innovation. And thinking about what we have in place now, taking aside the question of future regulation. Gabriel, we've had this UPC system in place for 2 years. Is it fit for purpose in encouraging the type of innovations? That gets confusing, isn't it? That you're both sitting there. Gabriel first, if you want to come in after. The male Gabriel. So is it fit for purpose? I think in particular when we're thinking about AI, which is an area that's moving so fast, is the UPC system as it is right now working to foster competitiveness and innovation in Europe?
Well, previously we had a quite fragmented judicial system. So UPC is bringing a sort of uniformity to that, and I think that's good. I don't necessarily agree with the trend of decisions, but it's up to the judge who do with the tools they have and with the law they have. But I mean, uniformity in European market is something which is good. But we should not have UPC replicating, I would say, what is happening in Germany with the rules which is available to the German judges. And they are doing what they are required to do with the tools they have. But what we've seen in Germany lately is that they didn't address the central question, which is how much. So I still need to know how much. And to me, as a manufacturer of products, that is the key point. And until now, this has not been addressed by UPC. That being said, UPC is quite new, and I think that at least getting something which is uniform and which might, I would say, disincentive forum shopping, because previously forum shopping existed, but UPC has a big, I mean, it's attractive because you're covering the whole market of countries who adhered to the UPC convention. And this seems to be more attractive than doing forum shopping, which was previously possible. So in that, it's a good thing. However, I would, as a manufacturer, I'm very jealous of the British people who have UK courts who take an awful lot of effort to determine a right. That is something which is quite time-consuming and so on. But, I mean, this right, this idea about this right could also be known if we had this aggregate royalty determination, which is part of the regulation. Why cannot we have this tool which brings predictability and could also help not just in litigation, but during negotiations? I mean, we have a lot of negotiations, but it's not because we finally reach an agreement that it's not a painful process. To me, they are too long. And stakeholders probably agree that negotiations are taking too much time, they are too long. But because we are sort of lacking independently agreed data points.
Lisa, do you want to come in?
Yes, not sure you're jealous of cost in the UK for cases. Huh? I'm not sure, because it might be much more expensive than having a license.
For sure,
finally.
It's not affordable for companies such as us.
Yeah, maybe I can add a little bit a different perspective. I've been from day one a big fan of the unitary patent system, starting with the unitary patent before we go to court. Simply, I mean, look at the world around, the addressable market with a unitary patent. I mean, if you want to be competitive in Europe, I mean, this is the place to go with a unitary patent, especially for international companies if you're in a niche in an area. But I think if you want to be seen comparable to US or China from a market, I think the unitary patent is the key. And then we have the unitary patent court system. And I think here we've seen, in my view, very good start. Then also on the point, who should set a rate? I'm having here a very special view. I think that courts could, or judges could say, this looks like a FRAND offer, but if they should set rate, I personally don't think this is the right approach. I mean, when you're in a negotiation in a company, and I'm doing this also like Sophie for many years, it's not an easy point what to put down, what is the price. And as much as I respect the judges, and I don't look if there's some in the room, but as much as I respect them, but they are legally, and sometimes I'm super surprised how much they understand from the technology, but now even the business side of it. I mean, I find it's very tricky to determine a rate, and we've seen rates where you cut off the top, to cut up the left, and you take the one in the middle. I mean, that doesn't sound like a very economically proper approach in it. And again, I mean, we have agreements, there are agreements in place, and of course, if judges see them, they could understand, is this offer FRAND? And then my final petitum on this, I think we've seen rates being set for my companies, but I promise you, none of these rates has ever made it exactly like this into the contract. That should show you that this is a good indication, but don't try to set rate. I don't think this is the right approach.
Steve, I know you wanted to come in on the rates, but I want to take this opportunity because there's actually a question about the rates, so I'll put it to you and then you can answer both. So the question is from Robert Pocknell. Recent UK case law has highlighted huge variances in rates paid by small and large companies. So how do we create a licensing system that enables European SMEs to be competitive and to innovate without discrimination? So also on the rates, particularly in the UK.
I don't know whether this question should be addressed to me or perhaps, I don't know, Gabrielle wants to respond. I just wanted to, perhaps I can just quickly respond to Gabrielle, the female Gabrielle. So I think generally you can have the view that judges are possibly not as qualified as economic experts on setting rates, but I think in the UK it showed that the courts are quite capable of it because they have the expert witnesses and have the data they need for that. And what is quite encouraging, I believe, is that UPC judges, even from the Court of Appeal, but also from the first instance courts, have indicated that they might be willing, even today, might be willing to, in a declaratory action, to look at license rates, which is, I think, a good thing compared to the German approach. So that is quite encouraging. On the question of Robert, I don't know whether someone else wants to respond to this. I think it's a specific problem.
Gabrielle, do you want to take it? You know, there's a related question here that I'll also put to you because it's also about the rates.
Yeah, but I mean, you have to understand that we are not talking about rates in public. So that's really also beside competition law, that if there are competitors in the room, we can never do that. So.
Let me see if you can take this one. So it's from Agnieszka Kupczak. How would licensees view draft SEP regulation if it would provide for very high aggregate royalty prediction, not based on market rates, as they would be set before a market has ever been formed? Would this not hinder follow-on innovation?
I think this is more a question for the ones that are in favor of the SEP regulation.
I mean, that was actually my argument in the beginning. It's all depending on how you implement the regulation in the end, operationalizing it. But I think there is definitely, if the system is fair, there is quite a risk that we will be unhappy with the aggregate rate that comes out of it. So that is definitely a risk, or let's say that is the system. That's something we would accept because it's, I mean, we ask for it. We ask for someone, a regulatory authority, to give us some framework. And if that rate is something we say, oops, that's even higher than before, or we thought,
then
that's
you would take
tough
it.
luck. Yeah?
Then you would take it.
Yeah, we will accept what comes out of that. But it's
then
an economic expert like PMAC or others are defining it and saying this is what we think is correct for the industry and for technology. That's something that's more than we have now, where, I don't know.
For the aggregate,
yes.
That's what you mean. But then comes the point on the how to distribute, and then, because that's, we are invited here by the European Patent Office, and I think what they've shown in this report is 5.5 million documents from standards. Great that they are. This is the only patent office that does it. But there's nothing in the regulation about validity of the patent. I just see in front of me that after there comes an aggregate royalty or whatever, but they say, yeah, but your share is different because 80% of the patents, and I don't agree to this, are not valid. That's what we heard before. So, and that's also not even addressed. So I just fail, sorry to say, to believe that, oh yeah, happy we are paying. I mean, in business, it's always like this. If one pays, and the other wants to get the money, you're always in disagreement. And you will always find new arguments. And I think this is the one argument. And coming back a little bit maybe to this, what we've seen here, this report which came out today, which gives us some data on it. And I would just, I mean, we are voting or talking to the USPTO and other patent office and say, use the standard documents. We need quality in the patents. And that is important, because then, if we then go with these valid patents around and license them, then we have a better solution as well. This has not been addressed by anybody, and I need to say it here.
The next audience question is for Liz. So this question is from Colette Ronsley. In terms of securing Europe's competitive edge, one of the objectives of the proposed regulation was to incentivize European companies to participate in and contribute to global standards. Would it?
Even if without talking about the regulation, I think it's a very good point, because it is all about the story. How we get a fair return of this huge amount of investment we do on standards. That's the point. And today we we already get this system in many patent pools, because we could remain that patent pools are very good solution right now, very good solutions right now. We have the chance to have a European agent. There are not so many at the worldwide level. We have one European, and most of the time in the different programs are taken into consideration your SEP, but also your contributions to standards, which demonstrates that it's not just about having a couple of SEP on your hands. It's really the way to recognize all these years of investments, constant investments. So it's a very good point, and it is all about the story and all about the liability we accept by offering access to our discoveries, because it decreases the value of our patents. By offering licensing through patent pools or through framework prices, it decreases the value of our patents. We all know that.
Well, I think we've heard a lot of different perspectives on the panel, a lot of areas of agreement, different perspectives on whether or not a new regulation is needed, for sure. But I think there's still, in terms of where we need to go, a lot of areas of agreement here. So yes. I want to thank, exactly. So I want to thank the panelists for a very excellent and lively discussion. How about a round of applause for them? And so it falls to me just to give a couple of quick concluding remarks here, kind of summing up the day that we've had. I mean, the point of today was really to talk about the intersection between the patent and standard worlds. And I think we've done that here in our 4 panels today, where we've really talked about how the two things affect one another and how both of those things impact competitiveness, as we've discussed on this panel. I think we've heard that all of the existing systems can be improved, both the ones that are being developed, the ones that have been in place 2 years. The systems that exist today are not perfect, and I think we've heard some good ideas about how to improve things, particularly when it comes to increasing Europe's competitiveness. Again, as the point was made here, the point of owning patents is not to sit on them and make money from them, it's to use them to innovate and to make great technologies that people can use and that businesses can benefit from. Particularly here in Europe, we're thinking about European businesses. And for European competitiveness, of course, it's key to strike the right balance between fostering the spread of new technologies in society while also in encouraging and rewarding innovation. So we want to make sure that the innovators get rewarded for all their hard work, but we also want to make sure that everybody can benefit from their hard work. And so the solution probably in the end is going to come from different stakeholders, all the different types of stakeholders in this room, the different types of stakeholders watching us online, but also the stakeholders not watching us, not in the room, but also very much part of this ecosystem. And so we know that from this point, there's further steps to be taken, both from the EPO with its new Patent Standard Explorer data set, the PMAC, and also its dedicated set of rules on SEP and FRAND disputes. Those have already proven that these types of solutions are within reach. And so this is a real call for further action as we think about everything we've talked about today. So Lise, you were asking if there were going to be some celebratory drinks to celebrate the launch. Yes, I have good news for you. So there will be a cocktail reception downstairs starting right now. So I invite all of you to head down there and enjoy. Take care.
Thank you.